November regularly scheduled session of the Tennessee Real Estate Commission. At this time, and prior to our executive director calling the roll, the executive director will read into the record some formalities.
This year's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since August the 9th of 2013. The notice of the November 5th, 2014 rulemaking hearing has been published on the TREC website since Thursday, August the 7th, 2014. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Thursday, October the 30th, 2014, and the meeting has been noticed on the Tennessee Gov website since Friday, October 31st, 2014. Now I'll call the roll. John Grease.
Here.
Janet DeChara.
Here.
Wendell Alexander.
Here.
Gary Bloom.
Here.
Grover Collins.
Here.
Marcia Franks.
Here.
Diane Hills.
Here.
Austin McMullen.
Here.
Thank you, Ms. Maxwell. At this time, if everyone will stand, Commissioner Bloom will lead us in an invocation and pledge to the flag.
Father, we're thankful for the opportunity to be here today to gather and to discuss important issues affecting our profession. We want to pray that the discussion will go well, that we'll honor each other in the way that we speak, and pray that good decisions can be made. Pray for wisdom for all involved in that decision-making process. And we, most of all, thank you for the opportunity to be making these decisions in a country that's free. And we're thankful for the fact that we're available to have our sins forgiven through Jesus, and we pray in His. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner Bloom. Just a quick note to attendees that are here at this point. If you are here to get continuing education or are required to be here for some reason or another, this is a 2-day session, so you'll have to be present for both days to get that continuing education or to satisfy a requirement that you might have to satisfy. If you're here for one day, we hope you participate, learn, and anything else you'd like to do, but you're not going to get continuing education. You've got to be here for 2 days to get that to happen. All right, members of the commission, there's a proposed agenda in front of you. Is there a motion to adopt this agenda, or is there a motion to amend?
I make motion we adopt the agenda.
Second.
I have a motion by Commissioner DeChara, seconded by Commissioner McMullen, that this agenda be adopted. Is there discussion on the motion? All right, hearing none, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. It passes unanimously. Next on the agenda is to approve the minutes of our last meeting in October. Is there a motion?
Motion to approve.
Motion by Commissioner DeChara, seconded by Commissioner Alexander. Is there discussion on the motion? All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, Commissioner McMullen abstains.
Please note, Commissioner McMullen abstained on that vote. So it passed on a 7 aye, 1 pass vote. All right, at this time, we're going to, Commission, go a little bit out of order here, but I think it's appropriate that we do it this way today. We'll ask legal counsel, and has everybody met Keeling? Keeling's a friend of Julie and filling in for Julie. And it's Keeling Baird. She's from Jacksboro, Tennessee, which has a great Walmart up there. I know that much about Jacksboro.
That's about the only thing.
No. Got a good Goodwill store there, too. So Keeling will take Julie's place. Will for the audience and for commission, we will stop at 9:15 or as close to that as we can to prepare for the rulemaking hearing, which will start at 9:30.
And you may need to back your speaker down a little bit.
You close to it?
A little feedback.
Okay. Thank you. All right, does everyone have a copy of the legal report on their iPad or on a paper copy? Are you all ready to go?
Yes, sir.
All right, Keeling.
Okay, I'll try to go as quickly as possible. I don't know if I'll be as fast as Julie, but we'll see.
You'll do fine.
Okay. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. So we'll start with item number 1, 2014-001241. This matter was presented previously at the June 2014 meeting. In 2010, complainant responded to a real estate ad and purchased a property from respondent broker who was owner agent of the property. Complainant states that respondent carried the mortgage, and complainant alleges that this violated laws regarding the licensing of mortgage lenders, loan brokers, and loan servicers. Further, complainant states that respondent failed to disclose hidden damage to the septic system of the subject property, which complainant states was caused by a neighbor connecting his front and rear gutters to a flex pipe and running the pipe onto the subject property and emptying into the leach field on the subject property, causing gutter water over time to damage the leach field. Complainant alleges that respondent knew of this and did not disclose it to complainant. Complainant attached a civil complaint against respondent, which alleged that complainant did not discover the problem until June 2013, when a contractor dug up the field lines and the problem was discovered. Complainant also provided a copy of documentation relating to the sale, including a real estate sales contract between the parties, which disclosed that respondent was a licensee. Respondent submitted a response stating that respondent had owned the subject property for 3 years, during which time the property was rented, before selling to complainant. Respondent states that a home inspection was done and respondent was asked to correct water seepage coming under a door leading to the garage, which respondent states was done. Complainant disputes that this was done to complainant's satisfaction. Respondent denies awareness of any French drains connected to the neighbor's home, but states that respondent knew and told complainant about drains on the home that complainant
Mr. Chairman, excuse me. Move to dismiss.
Second.
Based on the additional information that we have at the bottom, the court judgment finding that the respondent didn't deceive or misrepresent, and the other items that were found by the Chancery Court.
We've got a motion on the floor to dismiss this complaint made by Commissioner McMullen and seconded by Commissioner Franks. Is that right? Yes. Okay. Is there discussion on the motion?
Call for the question.
All right, the question has been called for. Those in favor of calling the question, say aye.
Aye.
Those opposed, no. It passes. Let's vote on the motion. The motion is to dismiss. All those in favor, say aye.
Aye.
Those opposed, no. It passes unanimously. Thank you, Commissioner McMullen. Numbers 2 and 3, please, Keeling.
Item number 2, 2014-014-501, and item 3, 2014-014-502. Previously presented at the October 2014 meeting, complainant entered into an exclusive buyer's representation agreement with respondent's firm. Respondent 1 is principal broker, respondent 2 is affiliate broker, with respondent 2 listed as a designated agent. Complainant states that complainant requested that respondent 2 offer $10,000 over the listing price of a home since it already had 2 offers on it. Complainant states that respondent 2 advised that complainant should only offer $5,000 over the list price and alleges that respondent 2 stated respondent 2 had made an under-the-table offer to rent the house back to the seller to give seller time to find a new home, which was done to ensure that complainant's offer would be selected and was not previously discussed with the complainant. Complainant's offer was not selected by the seller. Complainant states that respondent 2 breached the buyer's representation agreement since respondent 2 did not obey the lawful instructions of the client, and complainant states that the buyer's representation agreement should be terminated. Respondent 1 submitted a response stating that the buyer's representation agreement was set to expire in September 2014, and complainant was also represented by respondent 2 for the sale of complainant's home, which closed in April 2014. Respondent states that complainant requested to terminate the buyer's representation agreement and agreed to pay a termination fee to the firm, but did not disclose any of the issues alleged in the complaint. Respondent 1 states that several weeks later, a letter was received by an attorney on behalf of complainant, first alleging the matters included in the complaint. With regard to the property complainant was hoping to purchase, which was referenced in the complaint, Respondent 1 stated that complainant and Respondent 2 discussed increasing the offer on the property, but complainant chose not to do so and signed the purchase agreement with the terms included herein, and chose not to increase the offer, and the seller accepted another offer. Respondent 1 denies having knowledge of any under-the-table offer. Respondent 1 acknowledges complainant's frustration with not getting the home, but states that unhappiness does not automatically terminate a binding agreement. Respondent 2 also submitted a response which included the information in Respondent 1's response, but added that complainant viewed multiple homes with Respondent 2, and multiple offers were submitted but either withdrawn or terminated. Respondent 2 further states there was no under-the-table deal to rent the house back to the seller and states that the only way to have a lease agreement is for the buyer and seller to agree to the terms in the contract or by separate agreement. Respondent 2 contends that Respondent 2 followed all of complainant's instructions. The previous decision was the commission voted to defer this matter to allow Commissioner DeChara to review the file and report at the next meeting. New recommendation is for Commissioner DeChara to discuss.
Mr. Chara, are you prepared to discuss?
I am.
All right, would you please?
I still feel like this agent did not fulfill their fiduciary duty. There were text messages back and forth between the client and the agent. The client said to the agent, if we need to go up 5,000, you can. And the agent said, I was thinking that. And then the client said, if you need to go up 10,000, just get it. And her agent advised her not to do that. She said, let's don't go crazy now. I wrote it for 530,000, and she said, I really want this house. And her agent told her just to sit tight. And then the lady lost the deal over $1,000. Her offer was $5,000 higher than list price. The offer that beat hers was $6,000. And so she didn't get the house, and she contacted her agent again and said, can you call that agent and let her know your buyer wants to offer more money? I am just sick and dumbfounded on why we didn't go ahead and make my offer the first time. And the agent responded, she told me we had the deal. So evidently there was a little dealing under the table going on. And then when the client asked the agent to let her out of the buyer's rep agreement, the agent told her that she would give it some thought and do the right thing, but she had a lot of personal hours in this, and that she was just needed to think about it and would not release the lady from her agreement.
Questions for Mr. Chara?
So those are contradictory to what was given to our council, right? That information? No, this was what was given to council. Okay.
Mr. Chara, what's your recommendation?
My recommendation is a civil penalty for violation of not fulfilling her fiduciary duties.
Can I ask you a question, Janet? Was anything in writing, like the offer to increase by $5,000?
It was in text messages.
But did the agent actually prepare an amendment to the offer to increase the price that was signed by the buyer?
No,
Or that was countered by the seller?
no.
See, to me, I've got a bigger issue with that than I do with the failure to be loyal to the interests of my client.
Well, I feel like there's a lot of things this agent didn't do right. And number one is if somebody tells me they want the house and to go up $10,000 on it, I'm going up $10,000.
You're going to get it in writing, aren't you, though? You're not
Well,
gonna just not
absolutely.
send a text message over.
Well, absolutely, I'm going to put it in writing, but, I mean, the agent just pretty much refused to do that. She didn't think it was necessary.
Seemed to me like there was a lack of due diligence on the part of the principal broker. Where was he?
Well, the principal
Or she-
broker doesn't think there was any wrongdoing either, and I disagree with that. I think they're both at fault.
Well, Mr. Bloom, you have any comments?
Well, I just wondered if the request to pay $10,000 more was in the text message.
Yes, it was. The text message said, if you need to go up $10,000, 10,000 K, just get it. Or 10K, just get it. And the agent's response was, let's don't go crazy now.
All right,
Something to go. What's your recommendation on the fines, if that's what it is? Let's have a motion.
I think the agent, isn't that $1,000 penalty on that?
Looking, hold on just 1 second. Sorry.
take your time.
Okay.
Of course, failure to supervise on the part of the broker, $1,000.
What section of the law is that you're looking at, Janet?
Well, let Keeling,
Are you looking under 6213-312?
I think that's the right one.
It's also making a substantial and willful misrepresentation also.
Yeah, it is. Yes, it is 6213-312.
all right, to the audience, we're trying to determine the particular statute that has been violated per the recommendation of Mr. Chara, and we'll have that shortly here.
Like 6213-312B14. Violating any provision of this chapter, any rule duly promulgated and adopted.
You're not on the, your microphone's not working, I'm sorry.
And then 15 says, in the case of a licensee failing to exercise adequate supervision over the activities of any licensed affiliate brokers within the scope of this chapter.
Do we have any information on the principal broker? What do we know about the principal broker in this case?
Well, the principal broker did not feel like there was any wrongdoing on the part of the agent. We just have a letter from the principal broker.
Old principal broker had a $500,000 contract. He been paying attention.
Yeah, I would have a problem with my agent blowing a $500,000 contract. May have been. And
Let's do this one at a time, Janet. If we go to 6213-312-15, I think that's your failure to supervise.
right.
So your
That's-
motion on the principal broker is related to that,
Yes.
and what is your motion as far as penalty?
$1,000.
$1,000 civil penalty, and what about coming to one of these meetings?
Absolutely.
All right, within 6 months?
Is that for both?
Or just, I'm just taking the broker right now.
Okay.
All right, so the motion that, I'm not sure that I can even let you make a motion on this one, frankly, because you've got
No.
information about this. So I'll need a motion from someone else if they agree that's a proper motion regarding the principal broker, failure to supervise.
Mr. Chairman,
Mr. Alexander.
I move that the principal broker be fined not $1,000, $1,000 for that act plus the procurement of the days, extra days. How many days was it? Can we not do that? Mr. Maxwell?
What do you mean extra days?
Well, it runs so many days, and you can do,
Yes.
You have to be able to calculate the days, and so if you can calculate those days, Commissioner DeChar's got the file. I mean, if you could calculate those days, if you're talking about the days that the principal broker, like that went on, or that you would have to be able to calculate.
I'm
the-
looking for a way I can find the maximum.
Right, so
fine.
you would have to be able to calculate the days in a fairly exact manner.
Nobody else has a copy of that file?
Oh, I don't think so. Let's talk about
Okay,
this.
okay, let's just move on then, and I'll settle for the $1,000.
All right, Mr. Alexander's got a motion that still needs to be seconded that would penalize the principal broker or find a civil penalty of $1,000 to the principal broker and require that principal broker to attend a full commission hearing within 6 months. Is there a second to that motion?
Second.
Seconded by Commissioner Bloom. Now discussion on the motion related to the principal broker. You ready to vote? Those in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes
And I
unanimously
abstain.
with one abstain, Mr. Chara. Now, back to you, Mr. Chara, related to the affiliate.
Okay, I feel, I'm like, Ms. Franks, I feel like we have misrepresentation under 6213-312, B1, as well as, 20. And also under 6213-404, 1. And 2. She actually violated quite a few of those in the loyalty department.
All right, let's be specific. So you've got, at this point, you've got 3 different references. Do you
2, 20, 1, and 2.
so is that 3?
4.
4. Okay, let's go them one at a time then. Let's go to 6213-312.
B1.
Okay, so you want to make a motion related to that particular you want to put a civil penalty attached to that? We'll go down these one at a time.
What's the range on that one?
Range is $250 to $1,000 on B1.
I can't let Janet make the motion. Is there a member of commission who would like to make a motion related to that particular offense?
I think Ms. Franks did. She did part of the work on find it.
You have a motion?
I make a motion that we find the agent $1,000 for 62-13.312 for making, .1, for making a substantial and willful misrepresentation.
Is there a second to the motion? Second by Commissioner Alexander. Is there discussion on the motion? Mr. McMullen?
What was the misrepresentation?
She did not represent what her client had asked her to make the offer for.
I think that's different, though, than a misrepresentation. The misrepresentation, I think, would be that the agent said the facts are like this, and really they knew that the facts were something different. I think that what you may be talking about is more a violation of 6213-404-1 that says obey all lawful instructions of the client when they're within the scope of the relationship. And so if the client told her to do something, the agent to do something, the agent didn't do it, that sounds like more like that to me and not a misrepresentation.
However, Austin, the agent did tell the buyer that the other agent told her they had the deal at $5,000 over.
The agent could have told her that too, though. I'm in agreement with Austin. I'd like to amend my motion,
Let's withdraw it.
okay?
Okay.
You don't have a second, so.
So it's withdrawn. Now, Janet, your second reference was 6213-404.
Well, no, back up to 6213-312-20.
That's B, 312B20.
If commission will take a look at that, is there a motion related to that particular item?
Which one is it?
6213-312B20. All right, last call. Is there a motion related to 6213-312B20? All right, let's move on, Janet. The third reference you had was 6213-404.
403,
Oops, sorry.
1, diligently exercise reasonable skill and care in providing services to all parties in the transaction.
Mr. Chairman, I have a motion with respect to that.
Mr. McMullen,
I move that we find a violation of 62-13-403-1 incorporated through 62-13-312B-14, which says you can't violate any other provision of this chapter, based on the information that we've heard, as well as, I would say, 62-13-404-1 and 2 for failing to obey the instructions and to be loyal to the interest of the client.
Second.
Commissioner, you've incorporated 4 references.
Well,
I know
first,
one-
you start off on 62-13-312-B-14.
That's your authority for the next 3, then?
Right.
Okay.
And so that says you have the power to discipline if somebody has violated any other provision of the chapter. And then the other provisions are 4031, 4041, and 4042.
All right, I understand your motion. Is there a civil penalty you'd like to attach to that motion?
I'd recommend
Per
a
one?
$1,000 and attendance at a 2-day meeting.
Mr. Alexander?
That's $1,000 per each one of them?
Is that allowed? Can we go up to 1,000 for each of those, or is it just 1,000 total?
Not if you've got more than one act that you're or Rudy acting on, or can't you?
What's legal counsel's opinion on that?
I guess if you're going to cite 3 or 4 different actual acts, then yes, you could do 1,000 for each of those.
Okay, so,
That's your motion, Austin?
So 3,000.
okay.
Second that motion.
Motion by Commissioner McMullen, seconded by Commissioner Alexander, that the respondent, the affiliate broker, be fined $1,000 for each of 3 separate violations and be required to attend a meeting of the Tennessee Real Estate Commission, a full meeting of the Tennessee Real Estate Commission within 6 months. Is there discussion on the motion?
I would like to say, because both of the principal broker and the affiliate broker have a history of getting fines, that the monetary amount is appropriate.
Thank you, Ms. Franks. Further discussion? All right, let's vote. If you're in favor of Commissioner McMullen's motion, Mr. Bloom, I'm sorry.
No, I just wanted to thank Ms. DeChara
Thank
for
you.
doing that work.
Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes 7 ayes, no noes, and 1 pass. It was seconded by Commissioner Alexander. Thank you, Mr. Chara. All right, we're on number 4.
Item 4, 2014011211. Complainants are out-of-state residents who purchased 2 properties with respondent broker acting as their agent for purposes of repair and rental. With regard to property 1, complainants purchased the property in October 2012 without seeing it for $113,000 and spent $5,000 in improvements, stating no appraisals were provided and that respondent explained that it was not necessary and tenants should not be disturbed. Complainants state they visited the property in April 2014 and received an appraisal lower than the purchase price. Complainants state that they discovered faulty repairs which they had to pay to repair again. Complainants state that this reflects respondents' incompetency or lack of integrity and departure from Realtors Code of Ethics. With regard to property 2, complainants state they purchased the property in March 2013 without seeing it for $92,500 and an additional $27,500 was paid for repairs. Complainants state that respondent told them that the home would sell for $175,000 to $199,000. Complainants state that they were unaware that respondent was the owner of property 2 until they visited in March 2014. Complainants state that respondent gave them a 90-day expectation for remodels, but it was not completed for 5 months and was $15,000 over budget without any unexpected repairs. Complainant states that the house was put on the market for $169,900, and complainants learned that a more appropriate listing would have been $150,000. Complainants state that in January 2014, a severe winter storm caused the plumbing to burst, but insurance would not cover it because the home was vacant. Complainants state that they have paid an additional $17,000 out of pocket, and their contractor stated another $60,000 in repairs would be needed to prepare the property for sale or for rent. Complainants further state that respondent left town and left their property unlocked, resulting in theft of their microwave and oven. Complainants further discovered, after not receiving a tax bill, that property 2 was still titled to respondent despite their quitclaim. Respondent states that complainants were invited to come to Tennessee and view the area and neighborhoods they would be investing in, but declined. Respondent states that an inspection was ordered on property 1, and respondent denies, stating that it was not necessary to order an appraisal. Respondent states that complainants were advised of comparable sales and that complainants did not have a lender requiring an appraisal, but the one could be ordered to verify value. Respondent further states that after tenants moved out of property 1, respondent inspected the property, made recommendations for repairs, and hired a crew that respondent uses to rehabilitate homes. Respondent states that the new tenant was difficult, and respondent sent a licensed HVAC person to repair the air conditioning and also purchased and installed a window air conditioning unit and has not been reimbursed for the repairs. Respondent states that respondent gave complainants a recommendation for a non-affiliated management company after their business relationship ended. With regard to property 2, respondent states that respondent verbally discussed with one of the complainants that respondent's name was on the deed of property 2. Respondent states that property 2 was bought by different investors that requested the properties be held in respondent's name and requests complete privacy of their investments. Respondent states the home was sold for cost. Respondent did not make a commission, and the home was quitclaimed directly to complainants, which took longer than expected, and respondent could not locate a copy of the actual tax bill but was able to advise complainants the cost of taxes and the address. Respondent states that once they began rehabilitating the property, additional complications were found which took longer to repair. Respondent states that complainants did not pay any of the repairs that were over budget. Respondent states that the sales in the area had a range of $157,000 to $210,000, and the home was listed at $169,900 because it was completely upgraded. Respondent states that respondent visited the property during the cold snap to turn on faucets to drip and check the thermostat. Respondent states that when respondent was notified that the pipes burst, respondent immediately went to the house and had a crew come to work on water remediation. Respondent states that one of the contractors doing a quote agreed to lock up before leaving and evidently did not, resulting in the stolen range and microwave. Respondent states that this terminated their business relationship, and complainants refused to reimburse respondent. Complainants state that a more competent agent would not have allowed property 2 to sit on the market for 5 months. Complainants also state that the comparable sales provided for property 2 were from a nicer neighborhood close by. Complainants further state that respondent did not submit invoices or request reimbursement out-of-pocket costs, and the contracts they had state that respondent will stay within a specific budget. It appears that property 1's contract states the agreement is contingent upon the appraised value. Special stipulations include tenant to remain and lease to transfer. The contract for property 2 lists respondent as seller. Respondent signed as seller with the signature including a realtor notation. A confirmation of agency status form for the property lists respondent as seller and respondent as transaction broker or facilitator for buyers. The recommendation in this matter is to dismiss.
Is there a motion?
I want to have some,
Okay.
Discussion.
Let me see if I get a motion, and then we'll let you discuss.
well, I need, before we make that motion.
Wait just 1 second.
Okay.
You'll have all the time you want.
Okay.
Got a motion by Commissioner Collins to dismiss. Is there a second?
Second.
Second by Commissioner Franks. Ms. DeChara, it's your.
Okay, in the fact that they did not make sure that property was secured, I feel like 62-13-403, 1, diligently exercise reasonable skill and care in providing services to the parties of the transaction, was violated.
And you are absolutely free to make a substitute motion if you'd like to.
Well, I would like to make a substitute motion.
Go right ahead then.
That we assess a civil penalty of $500 for 62-13-403-1.
All right, this is a substitute motion offered by Commissioner DeChara. It requires a second. Is there a second to Mr. DeChara's motion? Commissioner McMullen?
Second the motion.
All right. Now on the floor is a substitute motion that would, if passed, fine or offer a civil penalty to the respondent of $500 and attendance at a Tennessee Real Estate Commission meeting within 6 months. Let's have discussion on the substitute motion. Mr. Collins.
To her point, who authorized the water remediation? According to what was written.
Well, what does that have to do with them leaving
Well-
the house unlocked?
It was my understanding that the buyer was the one that authorized it by their crew, not the guy that was selling it.
Well, it says respondent had his crew.
Respondent was the property manager in this case.
Yeah.
Mr. Collins, any other questions?
Seems like you got a third party guilty of negligence.
So that may be the issue as far as the vote goes. Was it the licensee's responsibility or the contractor's responsibility?
Call for the question.
Who made that? Is that you, Mr. Alexander?
Yes, it was.
All right, there's a call for the question. Is there an objection to the call? I hear none. So we're going to vote on the substitute motion, which is a $500 penalty in attendance at a TREC meeting within 6 months, offered by Mr. Chara, seconded by Commissioner McMullen. Are you ready to vote?
I'm sorry. Can we include in that motion 6213-312B, just because there's no
Perfect.
B14?
Thank you for that.
Okay.
All right. Let's vote. Those in favor of Mr. Chara's motion say aye.
Aye.
Those opposed, no.
No.
All right, the motion passes on a 6 aye, 1 no, and do we have a pass on that? I guess we'll make it 7 ayes and 1 no. Excuse me. Thank you, Mr. Chara. All right, Ms. Baird, we're on to number 5.
Item number 5, 2014-0114441. Complainant was a renter. Complainant states that written notice was given to respondent after living there for over a year, and respondent stated that complainant must pay the full month's rent for January 2014 that would be reimbursed the prorated amount as well as the security deposit. Complainant states that respondent did a walkthrough of the house and told complainant's spouse they would receive the full security deposit and the prorated rent as soon as possible. Complainant states that respondent was contacted multiple times, and respondent stated that the check would be put in the mail, but complainant never received the money owed. It appears from the lease that complainant began renting the property in April 2012, which was prior to respondent's licensure. It appears that respondent is the owner of the property. Respondent submitted a response stating that complainant gave written notice to terminate the lease and notified respondent that complainant would move out on January 15th. Respondent states that complainant was told to call after the home was cleaned to do a final walkthrough inspection. Respondent states that when complainant called requesting the deposit and prorated rent, complainant was advised repeatedly that the repairs were not yet complete and the remaining monies would be mailed back. Respondent states that respondent was contacted by an attorney for complainant, and respondent provided respondent's attorney contact information. Respondent confirmed that the deposit was dispersed to complainant after damages were assessed and repairs were made. It appears that respondent is the owner of the property who is not performing acts which fell within the definition of broker. Further, though this might be a landlord-tenant issue which would be heard in a court of law, it does not appear that there is a violation of the Broker Act. The recommendation is to dismiss.
Move to dismiss.
Second.
Who was my second?
Diane.
I'm sorry, thank you. We have a motion to accept council's recommendation and dismiss, made by Commissioner Franks, seconded by Commissioner Hills. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 6.
Item number 6, 2014-011-521. Complainant and spouse were sellers of a property, and respondent, principal broker, was the principal broker of the listing firm. Complainant states that a prospective buyer put down $1,000 in earnest money in 2012 but did not purchase the home. Complainant states the status of the earnest money is unknown, and respondent told complainant that the money was in escrow or in limbo and that both parties must agree on disbursement of earnest money before it is released. Respondent submitted a response stating that this matter has been turned over to the court for an interpleader action and attached copies of the documentation. Respondent states that respondent explained to complainant that the buyers could not meet complainant's request to put additional earnest money on the home, nor would they agree to early occupancy. Respondent states that the buyers signed the earnest money release form, but complainant would not. Office of Legal Counsel reviewed the documents, and the earnest money disbursement and release form is dated September 13th, 2012, and marked contract contingent upon the closing of August 17th, 2012 was not satisfied, and the form is signed by the buyer only. An interpleader action appears to have been filed on or about June 14th, 2014, after respondent received a copy of the complaint on June 7th, 2014. The recommendation is for a consent order for $500 for violation of Rule 1260-02-.09, highlighting subsection 3, which states that brokers are responsible for deposits and earnest money accepted by them or their affiliate brokers, and subsection 7, which states that funds in escrow or trustee accounts must be dispersed in a proper manner without unreasonable delay and should be dispersed or interplayed within 21 calendar days from the date of receipt of a written request, plus attendance by respondent at one entire regularly scheduled meeting of the commission within 180 days of respondent's execution of consent order.
Your motion.
I make a motion, we accept council's recommendation.
I've got a motion by Mr. Charles, seconded by Commissioner Alexander. Is there discussion on the motion?
Yes, Mr. Chairman.
Mr. Bloom?
I have a question. It appears all this activity was in 2012, and we didn't do anything with the earnest money till 2014. And then there's conversation. Now, I know the respondent and complainant can say things that may not be true, but when the respondent responded to where the earnest money is, he or she says it's in limbo. I don't know how you'd ever have earnest money in limbo. You all know where it is. And for 2 years, it appears he didn't know where it was until a complaint was filed and on the 7th, and a week later, then he responded and sent it for interpleader. So I don't think $500 is appropriate. I'd like to amend it to the maximum, which I believe is $1,000.
All right, I have a motion, and let's call it a friendly amendment at this point to the motion on the floor, which would be to raise the civil penalty from $500 to $1,000. Offered by Commissioner Bloom, seconded by Commissioner Alexander. Let's vote on the amendment if there's no discussion. If you're in favor of that motion, please vote aye.
Aye.
Opposed, no. It passes unanimously. Now we're to the main motion, which includes attendance at a regularly scheduled TREC meeting within the next 6 months. Is there discussion on the motion as amended? Let's vote. All in favor say aye.
Aye.
Those opposed, no. It passes unanimously. Thank you, Mr. Bloom. 7, 8, 9, please. Ms. Baird.
Item 7, 2014-012-931, Item 8, 2014-012-932, and Item 9, 2014-012-933. Complainant was a potential buyer, and Respondent 1 was complainant's agent. Complainant states that an extension was filed without complainant's authorization or signature. Complainant states that Respondent 1 alleges complainant signed the contract, but complainant states that Respondent 1 was advised over the phone that complainant would not sign another extension. Complainant states that upon receiving the paperwork, a copy of the extension with a settlement date of 8/15/13 was included, but it was the first time complainant had seen that extension. Complainant states that the settlement date on the form signed by complainant had been whited out. Complainant states that in order to receive the earnest money, complainant had to sign a contract releasing Respondent 1's firm from all liability. So complainant did not sign the form and has not received the earnest money. It appears that the contract was a cash transaction, with the seller being the Secretary of Veterans Affairs with a $500 earnest money deposit to a title company in Tennessee. There are also 2 extensions in the file that are signed by complainant on July 16, 2013 for a settlement date of July 29, 2013 with a written end date of July 30, 2013, initialed by complainant by the change date, and a second extension that is signed by complainant on July 16, 2013 for a settlement date of August 15, 2013, which does not contain initials next to the change date. There is also email correspondence provided between complainant and Respondent 1. An earnest money disbursement and mutual release of purchase and sale agreement was prepared for the earnest money to be returned to the buyer, complainant, with the explanation unable to close house in buyer's specified time frame, but it was not executed. Respondent 2 submitted a response stating that Respondent 2 is Respondent 1's principal broker for Tennessee and Respondent 3 is Respondent 1's principal broker for the neighboring state. Respondent's offices are located in Tennessee. Respondent 3 submitted information stating that Respondent 3 is responsible for licensees of the neighboring state and was responsible for supervision of this transaction. Respondent 3 states that when the issue is brought to Respondent 3's attention, Respondent 3 recommended returning the money to complainant, that the proper paperwork was prepared, that complainant would not sign the release paperwork, and that the earnest money is still with the title company. Respondent 1 states that during a telephone conversation with complainant agreed to a final extension of August 15, 2013. Respondent 1 states that a coworker who handles offers and extensions, who is also listed on the contract as a listing agent, made the change to the extension date, and Respondent 1 sent the form to complainant to initial by the date change. When complainant did not want to close, Respondent 1 states that Respondent 1 checked with the company that handles VA foreclosures regarding the earnest money, which initially refused to return the earnest money due to the second extension. Respondent 1 forwarded copies of the extension paperwork to complainant at complainant's request, and complainant contacted Respondent 3 stating the second extension was not properly executed. Respondent 1 states that it was determined that a mistake was made in the extension form uploaded was not initialed by complainant regarding the changed date. Respondent 1 states that release forms were sent to complainant from the coworker and the company that handles VA foreclosures, which provided for the earnest money to be returned to complainant upon signing the document. Respondent 1 states that complainant refused to sign. Respondent 1 states that the earnest money is being held at a title company in Tennessee and it will be released upon complainant's execution of the earnest money release. Although the earnest money is still being held, it appears that the contract authorized a title company to hold the earnest money funds, and the title company is holding those funds, and the broker is relieved of responsibility per Rule 1260-02-.095. The recommendation is to dismiss.
Is there a motion?
Move to dismiss.
I have a motion by Commissioner Franks to dismiss per council's recommendation. Is there a second? Last call. Is there a second to Commissioner Franks' motion to dismiss? All right. At this moment, that motion dies for lack of a second. Discussion or a second motion? Mr. McMullen.
I'm confused by the whiting out and the changing dates, and maybe I just missed it in the discussion, but did the complainant really authorize all of that, or were some things done that the complainant had not authorized?
Ms. Baird, do you have a take on that?
Chairman?
Just 1 second, Ms. Smith.
I'm a little bit more familiar with these because Julie actually prepared this. So, that was an allegation. That wasn't necessarily something that we saw. We didn't really have proof of that in the file.
So if it was emailed or faxed to you, you wouldn't see that whiteout though, would you?
I mean, we could send an investigator to inspect the original documents. I know,
Ms.
I can take
All right, Ms. Smith, I'm going
let
to,
me check to see if the date looks like it was changed on the form. Let me pull, there were several extensions in here. So if
before you
give
go
me
to
a
any
second.
trouble, let me recognize Mr. Alexander.
Chairman, I have a motion.
All right, sir, go ahead.
I move that this be deferred and it be given to Ms. Hills for her review and report back to us next meeting.
I'll second
I
that.
have a motion by Commissioner Alexander and seconded by Commissioner DeChara that this particular case be deferred for 30 days, and in the meantime, the file be handed over to Ms. Hills for her review and comments next month. Do you agree to do that?
I agree.
You don't have any choice. I'm making sure you do that, okay? All right, you've heard the motion. Is there discussion on the motion?
Yes, Mr. Chairman.
Mr. Bloom.
In that discussion, I'd like for us to review 1260-0209, number 3, which says that brokers are responsible at all times for the earnest money, regardless who holds it, whether it's a person or a firm, which seems to be in conflict for our decision that the broker might be relieved of this responsibility because it's being held by a title company.
Well, and I'd also like to make a point that the buyer did evidently request that earnest money back quite some time ago by signing a release, and something should have been done at that point as far as an interpleader or something.
But the broker can't do that if they're not the holder of the money. The title company would have had to done that.
They're still responsible.
They're still responsible. They could have initiated it.
See, we need to get that cleared up because that's not my understanding at all. I thought that once the title company had it, it was out of the broker's hands and had no further responsibility. So,
I agree with what he's saying, but that isn't what the rule
I know,
says.
the staff,
Get all of that back next month, call for the question.
all right. Mr. Alexander would like to cut off discussion and has called for the question. Is there objection to the call? All right, you've heard the motion, is to defer for 30 days with Commissioner's Hill review to be presented next month. Let's vote. Those in favor of the motion, vote aye. Aye. Those opposed, no. The motion passes unanimously. Thank you, Mr. Alexander. Ms. Baird, 10 and 11.
Item 10, 2014-013-101, and item 11, 2014-013-102. Complainants state that they met Respondent 1, affiliate broker. Respondent 2 was Respondent 1's principal broker at the time, at an open house, and Respondent 1 offered to write up the contract for complainants. Complainants state that they waived a home inspection because Respondent 1 stated that one was done 2 weeks prior and everything was fine, but complainants state they were unaware of needing a termite inspection. Complainants state that Respondent 1 told them that a termite inspection would be taken care of just before closing, although complainants state that they later found that the contract allowed 2 days for inspections. Complainants further state that when contacting an insurance agent, they were made aware that there may be problems with the roof. Complainants state that they were advised to allow the contract to expire and bring in their own representation. Complainants state that they reached out to Respondent 2 for help in resolving issues with the contracts. They could move forward with closing, but Respondent 2 offered no assistance. Complainants state that their new contract with their new agent was rejected, and complainants contacted Respondent 2 for an earnest money release and alleged Respondent 2 stated there would be no problem and Respondent 1 would take care of the paperwork, but complainants state that Respondent 1 ignored the topic. Documents submitted with the complaint include the purchase and sale agreement, which indicates that the earnest money was held at Respondent's firm. The Get a Home Inspection document was signed by complainant stating that complainants chose not to have a home inspection performed. Respondent 1 was listed as transaction broker for both parties on the signed confirmation of agency status form. An email dated May 21, 2014 from one of the complainants to Respondent 1 requests release of earnest money. Respondent 2 submitted a response stating that Respondent 1 is no longer affiliated with the firm. Respondent 1 submitted a response denying any wrongdoing. Respondent 1 states that Respondent 1 asked if complainants wanted a home inspection, and one of the complainants asked if there had been one done, and Respondent 1 replied that one had been done for a previously failed contract. Respondent 1 states they were told some of the items that could be expected in a 50-year-old home, but complainants decided they did not want to have a home inspection, and they completed and executed the form indicating so. Respondent 1 states the complainants were concerned about making the monthly mortgage payment, and in an effort to save the contract, the seller agreed to lower the price and the closing date was extended. Respondent 1 states that Respondent 1 received a phone call from the insurance company inquiring how old the roof was, and the seller stated that it was no more than 5 years old, but the insurance company was sending someone to inspect the roof. Respondent 1 states that another agent, a friend of the insurance adjuster, contacted Respondent 1 and questioned Respondent about the contract. Respondent 1 states that Respondent 1 sent a second extension to extend closing, but complainants did not communicate with Respondent 1 until several days later, when another offer was received for complainants written by the other agent. Respondent 1 states that the seller was not agreeable to this, and the deal fell through, and the earnest money was returned to complainants on May 30th, 2014. Respondent 1 submitted a letter from the seller stating that complainants live down the street from the subject property and frequently visit the property and tell buyers that the home is not livable, and Respondent 1 has done everything Respondent 1 can to sell the property, but complainants are interfering. It appears from this information that the earnest money was dispersed within the time specified in Rule 1260-02-.09. It does not appear that there is a violation by respondents. The recommendation is to dismiss.
All right, Commissioners, you've heard the narrative. Is there a motion?
Move to dismiss.
Motion by Commissioner Hills to dismiss. Is there a second?
Second.
Second by Commissioner Franks. Now, discussion on the motion to dismiss per council's recommendation.
Were these written on a TAR form, the contracts?
Ms. Smith has that answer.
And not that the TAR contract, excuse me, is required, of course, but that language would have been on there and they would have signed it.
Yes, they are on TAR forms.
It is? Okay.
All right. Other questions or discussion on the motion to accept council's recommendation to dismiss? All right, hearing none, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Mr. Collins recuses himself on that particular vote. Numbers 12 and 13.
Item 12, 2014-014-531, and item 13, 2014-014-532. Complainant hired a respondent's firm, Respondent 1 is affiliate broker, Respondent 2 is principal broker, to rent complainant's home. Complainant states that per the lease agreement with tenants, the tenants were to maintain the yard and gardens, but the tenants did not, and Respondent 1 discouraged complainant from taking action, stating that the yard could be repaired with security deposit funds. Complainant states that the first tenants moved out sometime in June of 2013. Complainant states that Respondent 1 hired a handyman rather than professional landscaper to repair the garden, but the work was never done. Complainant states that a professional landscaper was hired by complainant, and Respondent 1 initially agreed to pay an amount toward that, but now refuses to pay. Further, complainant states that the first tenants were supposed to pay for removal of a satellite dish they installed, but tenants have not paid, and complainant was charged. Complainant further states that the second tenants moved in July 2013, and Respondent 1 submitted a move-in, check-in report. The complainant learned from the second tenants that Respondent 1 had not been to the house for inspection and check-in. Complainant states that upon visiting the home, damage to the hardwood floor was discovered from the first tenants and pulls in the carpet, but Respondent 1 refused to charge the tenants. Complainant further states that the first tenants damaged 2 window sills and the first tenants did not finish the repairs, so the second tenants finished the repairs but did not receive reimbursement. Complainant states that Respondent 1 assisted the first tenants with the home purchase, for which Respondent 1 and the firm took a commission, and complainant states complainant was not notified of this conflict of interest. Complainant further states that the checkout form for the first tenants was not completed until after the second tenant's check-in form was completed, and complainant states the complainant was not reimbursed for the satellite removal. Complainant states that when contacted, Respondent 2 refused to speak with complainant but emailed to notify they were terminating the management contract with complainant. Complainant states that complainant received a hold harmless agreement from respondents which complainant has to sign in order to receive the second tenant's security deposit and other amounts which complainant states were promised, but complainant has been advised by an attorney not to sign it. Respondent 2 states that Respondent 2 acts as a broker, having certain agents who work as property managers, and Respondent 2 advises agents and assists with issues and questions. Respondent 1 states that the first tenants were excellent tenants who paid rent timely and took excellent care of the home. Respondent 1 noted scratches on the windowsill made by the dog during an annual inspection, and Respondent 1 states they repaired this before move-out. Respondent 1 states that there is no part of a rental agreement that hinders Respondent 1 from assisting tenants with the purchase after their lease has been satisfied. Respondent 1 states that while initially marketing the property for rent, Respondent 1 noticed scratches in the hardwood floors and some tears or pulls in the 15-year-old carpet, and upon move-out of the first tenants, one additional pull in the carpet was noticed, which was attributed to normal wear and tear. Respondent 1 further states that the second tenants were angry because the homeowners intruded by performing repairs for 2 weeks, and Respondent 1 ended up assisting the second tenants with the lot purchase. Respondent 1 states that complainant required a pet deposit from the second tenants for a cat that stayed crated in the home during a visit. Respondent 1 states that complainant is hard to please. Respondent 1 states they have offered return of the security deposit for the second tenants, the additional cat pet fee, a gardening fee, and money for the satellite dish removal in exchange for complainant signing a hold harmless agreement. But complainant contacted an attorney and asked for much more, including requests for repairs to the hardwood and carpet. Office of Legal Counsel followed up with respondents and received documentation relating to the property. It appears that the cost of satellite removal and an administrative fee for the repair were deducted from complainant's rent payment. Also, there is a fax memo regarding the repairs which states that the money should be taken from the $250 held from the first tenants. From accounting documents, it appears that the full security deposit was returned to the first tenants, but a $250 pet deposit was paid upon move-in, which appears to have been deposited to complainant at that time. It does not appear that complainant would sign the hold harmless agreement offered by respondents in order to release the second tenant's security deposit to complainant. However, it does not appear that there was a violation of the Broker Act by respondents. The recommendation is to dismiss.
All right, you've heard counsel's recommendation. That is to dismiss this complaint. Is there a motion to that effect?
So moved.
Is there a second?
Second. Motion
Motion by Commissioner DeChara, seconded by Commissioner Collins. Now, let's see if there's discussion on the motion. Commissioner McMullen, anything bothering you about this one?
Yes.
What?
But just at the beginning, it talks about that they hired a handyman to repair this stuff, and that work was never done, and the complainant had to hire someone else to do the repairs, and then at the end, it says that the full deposit was returned. I thought that's what it said, to the first tenants, and it seemed like that should have been used to pay for the repairs that had to be done. And there seemed to be some question about the respondent ever being there for these inspections, that it sounded like the respondent had claimed they were there for them. And then in the response, it didn't really seem to me that they directly addressed that to refute the allegation that they weren't there. I don't know if it's a direct conflict of interest, but it certainly raised some concerns for me that they were, that they were helping the tenant to find another property, and maybe that had colored the way that they actually helped these complainants with the property management.
So those are just observations at this point?
Well, I'm not sure it all rises to the level of violation or not, but there's certainly, it seems like there's smoke there. I don't know if I've seen a fire yet. But
Let me check with Ms. Smith. You heard his comments. Do you want to comment on any of his comments?
Might need just a minute to look at the respondent's response.
Okay, that's perfect. Take your time.
A lot of information with flags here.
I understand.
I did a lot of accounting and adding up.
While she's looking at that, to the audience, the Real Estate Commission gets all kinds of complaints every month, and it's up to legal counsel's staff to try to figure out how to present them to us without identifying who the people are, what company they work for, what part of the state they're in. And it's a difficult task for them to do it, and it's up to this commission to hear their recommendation and the narrative, and then make a decision whether we accept the recommendation, want to modify it, or increase the recommendation, whatever that might be. And then, if there's a civil penalty offered, it's presented to the licensee, and they can accept or reject it. This is basically just an offer to settle. If they choose not to accept it, then they have every right to come here for a formal hearing, which will include an administrative law judge, court reporter, sworn testimony. And for those of you who are going to be here tomorrow, we have such a case tomorrow morning.
Another question, maybe I'm misunderstanding this, but and I thought I heard this in a prior complaint we heard as well, but I really noticed it here. At the end of the first paragraph, maybe it's the second paragraph. No, first paragraph. It talks about that the respondent was going to give the second tenant security deposit to the complainant, but was requiring the complainant to sign a release of the broker. If that money was owed to the client, to the complainant, why is the broker able to get or require the client to sign a release in order to give them the money that they're supposed to be giving them anyway? Or am I misunderstanding that?
I think it's a fair question. I think most brokers would prefer, if they're going to give you the money back, to get a little something back in return, like you can't sue me. And whether that's right or not, I understand
Right.
your position.
I like getting releases too.
I know you do. For the audience, Commissioner McMullen is an attorney. He's a public member of the Real Estate Commission, not a licensee, and we rely on him often and strongly. But he keeps throwing these things out, not doing anything with them, so.
Mr. Chairman,
Mr. Alexander,
I think you need to explain to the audience that our two council substituting today, that our regular council is not out.
That's
and
true.
Jenica's not, she's here.
I'm a paralegal.
She's our paralegal.
Yeah, I know that, but
I don't want you to think that.
Have you found anything in that file that you want to share with Commissioner McMullen?
It does appear that the respondent performed the move-in and move-out and annual inspections himself. I'm looking for the question regarding the release and the hold harmless.
Typically, Mr. McMullen,
we
we
do
have
have a
a
motion to
mutual
dismiss.
release form that we have the buyer and seller, or in this case, the complainant and respondent sign, that shows that everybody agrees on who's to get the earnest money.
Okay.
So at this point, we have a motion to dismiss on the table. Yeah, if it fails, we can have a new motion. I'm still waiting for Ms. Smith to see if she has any additional information for Commissioner McMullen.
Make a motion that we put this one at the heel of the docket, and that way we can spend a little time maybe during the break looking for this documentation, and then we could come back to it.
All you non-attorneys know what the heel of the docket is? When exactly does that occur?
Put it
Mr.
at the
McMullen?
end. Put it at the end.
End of what? Today's meeting, tomorrow's meeting?
The end of the legal report.
End of the legal report. We may finish it up before this break.
Well, we'll see. We'll cross that bridge when we get to it.
All right. Is there objection to moving this item down on the docket? Also known as the agenda, I guess.
I second his motion.
I hear, without objection, we'll do that. Let's move on, Ms. Baird, to number 14.
Item 14, 2014014731, complainant was the seller of a property, and respondent principal broker was complainant's agent. Complainant states that respondent failed to furnish a copy of any listing, sale, or contract relevant to the transaction to all signatories at a time of execution, stating complainant had to obtain a copy of the contract from the title company 17 days after signing the contract. Complainant states that respondent was hiding something by not providing the contract, and they only had verbal statements regarding commissions because paperwork was not given. Complainant further states respondent failed to account or remit money and showed the home without pre-qualifying people. Complainant further states that 2 days after signing the contract, complainant learned that complainant's mother is on the note and has refused to sell or allow complainant to sell complainant's part, and respondent did not immediately notify the buyer of this fact. Respondent denies all accusations, stating that respondent sent copies of the contract via certified mail to the 2 addresses where respondent knew complainant was staying, but both letters were refused 3 times and returned. Respondent states the complainant signed the contract in the driveway of the property where complainant was staying at the time, and respondent notified complainant that complainant could pick up the paperwork from respondent's office at any time, but complainant did not do so, and complainant would not provide complainant's mailing address. Respondent states the complainant signed a listing agreement to sell the property with a 6% commission, that respondent found a ready, willing, and able buyer, and that complainant accepted the offer. Respondent further states that complainant contacted respondent stating that complainant's girlfriend thought the purchase amount was too low and did not want to sell, and later told respondent the complainant's mom was on the deed. Respondent states that the deed only had complainant's name on it, and complainant stated complainant was not selling. Respondent explained that there was already a binding contract and it was too late to change complainant's mind. Respondent further states that complainant denied entry to buyer for an appraisal. Respondent provided documentation including a copy of the executed listing agreement and executed sales contract along with the returned certified mail envelope showing delivery attempts. Also provided was a warranty deed that conveys property from a family member to complainant. Also provided was a quitclaim deed dated after the complaint was initially filed, wherein complainant appears to have quitclaimed the property to complainant and complainant's girlfriend. Based on the information contained within the file, although a copy of the contract was not provided immediately, very soon after the contract was executed, there were already issues indicating that complainant did not want to go through with the sale, and respondent provided proof that there was an attempt to mail the copies by certified mail to complainant at 2 different addresses, and the letter was not claimed after multiple attempts at delivery. Recommendation is for a letter of warning regarding TCA 62-13-312-B8 regarding the Commission's ability to discipline a licensee for failing to furnish a copy of any listing, sale, lease, or other contract to all signatories at the time of execution.
All right, Commissioners, you've heard the narrative. Is there a motion? Just about to the heel of the docket at this point, so.
I'll make a motion, we accept council's recommendation.
Who's my second?
Hills.
Hills, Commissioner Hills for second. Okay, the motion offered by Commissioner DeCharo and seconded by Commissioner Hills is to accept council's recommendation and send the licensee a letter of warning. Now, discussion on the motion.
Call for the question.
Colin, the question's been called. Is there objection to the call? Let's vote. Those in favor of the motion vote aye. Aye. Excuse me, those opposed no. Motion passes unanimously. Back to you, Mr. McMullen.
Mr. Chairman, on number 12 and 13, I'd like to make a substitute motion. I'd like to find a violation of Section 6213 312B14 for violation of other parts of the chapter, and specifically 6213 4031, failure to diligently exercise reasonable skill and care in providing services, and 6213 4041, failure to obey lawful instructions of the client, and 6213 4042, failure to be loyal to the interest of the client with respect to the hiring of a person to do repairs and the work was never done, the complainant having to hire someone to make the repairs and the money not being used from the deposit to pay for that, but instead the money being returned to the tenants. That's the basis for my motion.
So, are you, 3 subsections, is that what you've got?
And what about penalties?
I would suggest a civil penalty of $1,000 and attendance at a meeting within 180 days.
I'll second that.
Was that for each violation?
Total.
That's for 1 and 2 both?
So the motion on the floor is, and you all have got the references, right? Okay, is that this licensee be offered a civil penalty of $1,000 and be required to attend a full Tennessee Real Estate Commission meeting within the next 6 months. Is there discussion on the motion? Mr. Alexander.
Had an affiliate and a principal broker involved in 2 entities. Are you, Mr. McMullen, are you including the civil penalty for both
Yes, I am.
complaint?
All right, that's fairly significant. New addition to the motion. This motion includes both the principal broker and the affiliate. So each would be fined $1,000. Each would be required to attend a Tennessee Real Estate Commission meeting within the next 6 months.
180 days.
Careful, Commissioner Collins.
You want me to hit him?
No, not yet.
Question.
All right,
Call for
the
please.
question's been called for. Is there objection to the call? Let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously. One more thing on the legal report is the consent order log. I think commissioners have been all provided a copy of that. Are there any questions, or Ms. Baird or Ms. Smith, do you have comments on that you'd like to make?
Will be accepted as presented.
I have a motion by Commissioner
Second.
Commissioner Alexander, and seconded by Commissioner Franks that we accept the consent order log. Any discussion?
Yes, Mr. Chairman.
Mr. Bloom.
Just at the bottom of that list, we have some things pending from March. And it says contacted by respondent who said would not accept the civil penalty, I guess, and requested a formal hearing. So we've had 7 months to set up a formal hearing.
Ms. Smith?
The litigators have several other boards that have cases that are over 600 days old, so they've been told to litigate those first. So we're just trying to get that backlog out, so it might be a few more months before the notice of hearing and charges is filed and a date is set. And I believe they are waiting to hear from the APD for new dates for 2015. So that's also a delay in filing those.
What is APD?
I'm sorry, Administrative Procedures Division. They're the governing body that gives us a judge for our hearings.
So is the answer it's out of our control and out of your control?
Well, the attorneys are in our office, so we are working with them. I believe those matters have been assigned to attorneys at this point, so they're kind of moving forward. It just might be slower because of the backlog.
But there's others that have been moved forward well in advance of this. I mean, we're scheduling hearings for people of cases in July and August, and here's March, and we're doing nothing.
Mr. Bloom, I may be able to help answer your question.
Are you Tony?
Say again, sir?
What is your name?
My name is Tony Glandorf, sir.
Okay, that's-
And I want to introduce myself if I could. I'm the chief counsel for the Regulatory Board's Legal Division. Keeling Barrett, I supervise her. I supervise Julie Kropp and all the other board attorneys for all the programs. Mr. Collins, I went to law school with your son. And I think I met you maybe 5 years ago when I first came on here, and I probably haven't seen you since. I could probably help explain a little bit about the litigation portion, if you would like, sir.
Sure, that'd be great.
Tony, Mr. Glandorf?
Yes, sir.
Whichever you prefer to go by. So we've got a hard deadline of 9:30 to start
Yes, sir.
And if you can summarize it shortly, or we'll put you on the agenda later at your schedule, when your schedule allows it. If it's a quick answer, we'll let you go.
I'll do it in 60 seconds
Okay,
or less, sir.
thank you.
I can do that. Currently, within our department, within the legal department, we have approximately 450 cases that need to be litigated throughout 22 boards and commissions. We have 6 litigators, and we have that list that is compiled, and we did compile that list with the oldest first, going down to the newest. So the charge to the litigators currently, this was a recent charge, which is to litigate the older cases first. That's why you would have had cases that were not so old that were litigated previously, because it was kind of on a priority issue to litigate those cases that can be litigated. They may be better to litigate now because they're fresh allegations or whatnot. So we've been charged with litigating those older cases first. So the case oldest 1,000 days old down to the lowest, and we have divided those up amongst the litigators. So they've been charged to do that. We do have a caveat, though. If there's any case that the director or the board feels that it needs to be immediately looked at, then we will file charges on that direction.
Mr. Bloom, did you get you a satisfactory answer there, did?
Not really. I don't know why we're waiting 7 months to litigate 2 issues, is my question.
If we could get the names of those cases or whatever they are, then we can put those on the top of the priority list for us
Great.
to litigate.
That'd be great.
If
Thank
we
you.
could, if we could get those, do you have those, Eve? Do you have those? Okay.
Now, did
Please
you get a
those to me.
satisfactory answer?
Yes, sir.
Thank you, Mr. Bloom. All right, just a couple of quick announcements before we take a break. We have a rules-making hearing scheduled for 9:30 today. If you want to speak at that hearing, you must sign up, and there's a list in the back. And we will take that list up shortly into the rulemaking hearing. So if you think you want to speak and later choose not to, you can say, I don't want to speak, but I encourage you to put your name on the list, because once that list is taken up and brought up here, we won't accept any other oral comments. Just fair warning. All right, we will start this rulemaking hearing at 9:30. I encourage people to be back in their seats about 25 after, just so we can get this thing going on time. We're on a 10 to 15-minute break at this point. If you'll start finding your way to your seats.
Got the list of people? Who's going to call the names out?
Just as soon as our court reporter is ready to go, we'll get this session started.
This is yours.
While we're getting ready to get started, once again, I'll advise you, if you think you may want to speak to this commission on one of the rules, proposed rules, you need to sign up. We will take that sheet up well before everybody talks. So make sure if you have some inclination to speak about a particular rule, your name is on the list. One more procedural issue. Are you ready, Ms. Dillon? Take your time. Take your time. The podium that we expected that you all to come up to and speak from is not wired for sound, so we'll ask you to come up to this center chair with the microphone in front of it, if you don't mind, those of you making comments, and use that so that we can record your comments and make sure everybody else in the room can hear them. Okay, Ms. Baird.
I'm ready, I apologize. This rulemaking hearing is called to order. The commission has agreed upon some guidelines for the rulemaking hearing, which Chairman Grease will now read.
Thank you, Ms. Baird. In our meeting in Chattanooga last month, the Tennessee Real Estate Commission discussed and agreed upon certain rules for this rulemaking hearing. I'll read those to you at this point. The Commission will accept written comments received by the Tennessee Real Estate Commission staff prior to or during the November 5th, 2014 rulemaking hearing, as well as oral comments presented at the November 5th, 2014 rulemaking hearing. The comment period for both written and oral comments will end when the oral comment portion of the November 5th, 2014 rulemaking hearing concludes. No comments will be accepted following the conclusion of the comment portion of the November 5th, 2014 rulemaking hearing. So, just as an aside, if you've got something in writing you want submitted as part of the record, you can submit that as long as this hearing is in progress. But once it closes, we'll not accept other comments. There'll be a sign-in sheet for anyone who wishes to address the Commission at the November 5th, 2014 rulemaking hearing. Anyone who wishes to address the Commission must sign in on that sheet. Once the sign-in sheet is taken up after the hearing begins, additional individuals will not be permitted to add their names to address the Commission. During the November 5th, 2014 rulemaking hearing, commissioners may ask a commenter to clarify the commenter's position. However, the intent of the rulemaking hearing is for the Commission to receive comments and not to engage in a dialogue with commenters. There will be a 5-minute limit to oral presentations at the November 5th, 2014 rulemaking hearing. Each person who wishes to make oral comments will have a single opportunity to make comments for a maximum time of 5 minutes. No commenter will be permitted to reserve time to comment later or to assign remaining unused time to another individual. It'll be the responsibility of the chair to tell you when your time starts and to tell you when 5 minutes is up and ask you to quit at that point. Don't take it personally. The Commission asks that each commenter begin by clearly stating the rule or rules to which he or she is speaking and then expressing his or her thoughts on that proposed rule. In the event commenter has more than one proposed rule to address, the Commission requests that the commenter reference each rule separately during the commenter's remarks. As the November 5th, 2014 rulemaking hearing is dedicated to specific proposed rules, comments related to other topics will not be entertained by the Commission. That also will be up to the chair to tell you you can't talk about that. So I'll be the bad guy, but I'm backed up pretty good here. The Commission will respond to written and oral comments during its January 7th, 2015 meeting prior to adopting the rules, with any amendments offered by commissioners following review of both the oral and written comments. Are there any additions commissioners would like to make or any other statements before we get started? All right, I hear none. Ms. Baird, back to you.
And just to follow up on what you said, I would like to make those guidelines that you just read an exhibit to the record. The information regarding November 5th, 2014 rulemaking hearing of the Tennessee Real Estate Commission, just like to make that an exhibit to the record.
We'll get that to Ms. Dillon.
Okay.
All right.
Chair.
1 second, please.
Okay.
Mr. Bloom.
I wonder if we could also address it after our January meeting, what the procedure is with the state, Ms. Maxwell, to,
I think that's going to come later.
okay, I'm
Yeah.
sorry.
No, you're fine. My name is Keeling Baird. I serve as a staff attorney in the Department of Commerce and Insurance, Division of Regulatory Boards, and serve as attorney for the Tennessee Real Estate Commission. Would the agency representatives who are present introduce themselves for the record?
Start with Ms. Maxwell.
I'm Eve Maxwell. I'm the Executive Director for the Tennessee Real Estate Commission.
Ms. Baird has introduced herself. Ms. Smith.
I'm Jenica Smith. I'm a paralegal with the Regulatory Board's Legal Division.
Mr. Glandorf, do you want to be on the record?
I surely will. My
Okay.
name is Tony Glandorf. I'm the Chief Counsel for the Regulatory Boards Division for Department of Commerce and Insurance. Thank you.
Thank you. Are there other representatives of the Department of Commerce and Insurance here today? All right, Ms. Baird.
It is Wednesday, November 5th, 2014. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 45204 in Conference Room 1A of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on rules the Tennessee Real Estate Commission is proposing to update certain existing rules relating to topics such as termination of affiliation, managing escrow or trustee accounts, and advertising, and to create other new rules relating to duplicate or confusingly similar firm names, appearances before the commission for the purpose of obtaining a license, military applicants, reinstatement of an expired license of a broker, affiliate broker, timeshare salesperson, or acquisition agent, commissions earned by affiliated licensees, electronic records, and licensees who hold themselves out as a team, group, or similar entity within a firm. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and after adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Chairman Grease now has the sheet containing the names of all members of the public who signed up to speak. Only those who signed up will be permitted to speak.
Okay, so Chairman Grease does not have it yet. This is the last call. If anybody wants to sign up, please do so now. Jenica, if you wouldn't mind getting that for me. Once that list is delivered up here, it'll close the list of people permitted to speak today. Anyone else? All right, for the record, we now have a list of those who will be permitted to speak today, as long as they're speaking on the proposed rules. Ms. Baird.
Comment period for both written and oral comments will end when the oral comment portion of this rulemaking hearing concludes today. The Commission has determined that comments will not be accepted following the conclusion of the comment portion of today's hearing. The notice of rulemaking hearing, including the entire text of the proposed rules, was filed with the Secretary of State and published in its Administrative Register website on August 4th, 2014. Mrs. Maxwell, what additional notice was given to the affected individuals or groups?
The notice of the rulemaking hearing was published on the TREC website on August the 7th of 2014, sent to those individuals signed up to receive notices from notify.gov on August the 7th of 2014. Notice was given to the Tennessee Association of Realtors, and the date of the hearing has been noted during the September 2014 and October 2014 commission meetings.
The commission has made the determination that oral presentations will be limited to 5 minutes per person, which will be done in a single presentation, and it will not be permitted to reserve time to comment later on or to assign unused time to another individual. The commission is limiting oral presentations so that the length of the hearing will not be unduly increased by reason of repetition. Please limit your comments accordingly. Additionally, when making oral comments, the commission asks that each commenter begin by clearly stating the rule to which the commenter is speaking before addressing thoughts on a particular rule. In the event that a commenter wishes to address more than one proposed rule, the commission requests that the commenter reference each rule separately during remarks. Additionally, this rulemaking hearing is dedicated to specific proposed rules, which will be summarized thoroughly for the record shortly, and comments relating to other topics will not be entertained by the commission, as the purpose of this rulemaking hearing is to provide an opportunity to present facts, views, or arguments relative to the proposal under consideration. At this time, I will read the substance of the proposed rules into the record. So we will start with the first rule is new rule 1260-01-.18, duplicate or confusingly similar names. This proposed new rule states that the commission reserves the right to refuse to issue a new firm license in a name which is the same or confusingly similar to another firm license already issued, and outlines the process for review of an application for a determination regarding the name. This rule is based on an existing commission policy which is more appropriately addressed within a rule, and the purpose of this rule is to protect the public from confusion regarding licensed real estate firms. New Rule 1260-01-.19, informal appearances before the commission. This proposed new rule is based on an existing commission policy which is more appropriately addressed within a rule. This rule states that any applicant for licensure appearing before the commission for an informal appearance must also ensure the presence of his or her principal broker or intended principal broker. Informal appearances are often utilized in the case of an applicant who has disclosed circumstances in his or her background which would call into question whether the person has a good reputation of honesty, trustworthiness, integrity, and competence to transact the business of broker, affiliate broker, or timeshare salesperson referenced in TCA 6213-303A1. In certain cases, those individuals arrive for an informal appearance where the commission considers the circumstances and determines whether satisfactory proof of honesty, trustworthiness, integrity, and competence to transact the business of a broker, affiliate broker, or timeshare salesperson has been presented to warrant granting licensure. As the supervising individual over licensees affiliated within a particular firm, the principal broker's presence and participation is important in this dialogue and determination. Rule 1260-01-.20, military applicants. This proposed new rule provides for the expedited processing of applications for certain military personnel and their spouses, the recognition of education earned through military service, and the allowance of license renewal for 6 months from the release from active duty without penalty when certain specified circumstances are met. Rule 1260-01-.21, reinstatement of an expired license of a broker, affiliate broker, timeshare salesperson, or acquisition agent. This proposed new rule clarifies certain discretionary provisions regarding reinstatement of a license, which are found within TCA 6213-319, and is based on an existing commission policy which is more appropriately addressed within a rule. This rule outlines the possibility of a medical waiver request, the requirements for renewal of a license within 60 days of expiration by way of providing proof of compliance and payment of specified penalty fees, the requirements for reinstatement of a license after 60 days of expiration by way of executing a reinstatement order, providing proof of compliance, payment of specified penalty fees, and attendance at a commission meeting, and the requirement for reapplication for licensure when a license is expired for more than 1 year. Rule 1260-02-.02, termination of affiliation. This amendment is based on an existing commission policy which is more appropriately addressed within a rule and will add an additional paragraph to the existing rule which provides for circumstances where a firm transfer request is submitted online. The amendment states that the transfer of affiliated licensee to a new firm is recognized as completed at the time of the online transfer request. Certain conditions are met, including but not limited to receipt by the commission of a completed and signed Tennessee Real Estate Appraiser Commission Form 1 within 5 business days of the date of the online transfer request. Rule 1260-02-.09, deposits and earnest money. This amendment will rename the rule to managing escrow or trustee accounts and provide some clarification as well as multiple new provisions relating to the management of a real estate firm's escrow or trustee accounts. The language of the rule as it is currently written resulted in inquiries from licensees seeking clarification regarding its provisions. The amendment includes definitions of the terms commingling and trust money as used within the rule and attempts to clarify multiple existing provisions of the rule and utilizes definitions to assist in the clarification. In addition, the amendment adds provisions specifically stating that commingling of funds within firm accounts is prohibited, which was not directly specified in the existing rule. Finally, the amendment adds an additional paragraph based on an existing commission policy, which is more appropriately addressed as a rule, outlining the management of interest-bearing escrow or trustee accounts if said accounts are utilized by a firm. Rule 1260-02-.12, advertising, and I'm going to read this rule in its entirety. Says advertising is amended by deleting the text of the rule in its entirety and substituting instead the following language so that as amended the rule shall read. Section 1. All advertising, regardless of its nature and the medium in which it appears, which promotes either a licensee or the sale or lease of real property, shall conform to the requirements of this rule. The term advertising for purposes of this rule, in addition to traditional print, radio, and television advertising, also includes, but is not limited to, sources of communication available to the public, such as signs, business cards, flyers, letterheads, email signatures, websites, social media communications, and video or audio recordings transmitted through internet or broadcast streaming. Advertising does not include promotional materials that incidentally advertise a licensee, such as hats, pens, notepads, t-shirts, name tags, and the like. Section 2, for purposes of this rule, the term firm name shall mean either the following. Part A, the entire name of the real estate firm as licensed with the commission, or Part B, the doing business as name, if applicable, of the real estate firm as licensed with the commission. Section 3, under general principles, Part A, no licensee shall advertise to sell, purchase, exchange, rent, or lease property in a manner indicating that the licensee is not engaged in the real estate business. Section B, all advertising shall be under the direct supervision of the principal broker and shall conspicuously list the firm name and the firm telephone number as listed on file with the commission. With regard to the size and visibility of the firm name and firm telephone number, all of the following shall apply. Number 1, the firm name must be the most prominent entity featured within the advertising, whether it be by print or other media, and Number 2, the firm's telephone number shall be featured in greater size and or prominence than the telephone number of any individual licensee or group of licensees. Part C, any advertising which refers to an individual must list the individual licensee's name as licensed with the commission, and the individual licensee's name may not be any larger than the smallest font of the firm name. Part D, no licensee shall post a sign in any location advertising property for sale, purchase, exchange, rent, or lease without written authorization from the owner of the advertised property or the owner's agent. Part E, no licensee shall advertise property listed by another licensee without written authorization from the property owner. Written authorization must be evidenced by a statement on the listing agreement or any other written statement signed by the owner. Part F, no licensee shall advertise in a false, misleading, or deceptive manner. False, misleading, and or deceptive advertising includes, but is not limited to, the following. Number 1, any advertising that refers to an individual licensee utilizing a nickname where the nickname is not included within the licensee's name as licensed with the commission. Number 2, any advertising that includes only the franchise name without including the firm name. Number 3, Licensees who hold themselves out as a team, group, or similar entity within a firm who advertise themselves utilizing terms such as real estate brokerage, realty, company, corporation, LLC, CORP period, INC period, associates, group, or other similar terms that would lead the public to believe that those licensees are offering real estate brokerage services independent of the firm and principal broker. Number 4, any advertising that utilizes pictures including both licensed and unlicensed members of a team, group, or similar entity within a firm but which does not clearly identify the licensed individuals by name. Or number 5, any web page that contains a link to an unlicensed entity's website where said entity is engaged or appears to be engaged in activities which require licensure by the Commission. For advertising for franchise or cooperative advertising groups, Part A, any licensee using a franchise trade name or advertising as a member of a cooperative group shall clearly and unmistakably indicate in the advertisement his name, and firm telephone number, all is registered with the Tennessee Real Estate Commission, adjacent to any specific properties advertised for sale or lease in any media. Part B, any licensee using a franchise trade name or advertising as a member of a cooperative group when advertising other than specific properties for sale or lease shall cause the following legend to appear in the advertisement in a manner reasonably calculated to attract the attention of the public. Each, and then in parentheses, franchise trade name or cooperative group office is independently owned and operated. Part C, any licensee using a franchise trade name on business cards, contracts, or other documents relating to real estate transaction shall clearly and unmistakably indicate thereon. Number 1, his name, and firm telephone number, all is registered with the Commission. And number 2, the fact that his office is independently owned and operating. Number 5, Internet advertising. In addition to all other advertising guidelines within this rule, the following requirements shall also apply with respect to Internet advertising, including but not limited to social media. Part A, the firm name and the firm telephone number listed on file with the Commission must conspicuously appear on each page of the website. Part B, each page of a website which displays listings from an outside database of available properties must include a statement that some or all of the listings may not belong to the firm whose website is being visited. Part C, listing information must be kept current and accurate. This requirement shall apply to first-generation advertising as it is placed by the licensee and does not refer to such advertising that may be syndicated or aggregated advertising of the original by third parties outside of the licensee's control and ability to monitor. Number 6, guarantees, claims, and offers. Part A, unsubstantiated selling claims and misleading statements or inferences are strictly prohibited. Part B, any offer, guarantee, warranty, or the like made to induce an individual to enter into an agency relationship or contract must be made in writing and must disclose all pertinent details on the face of such offer or advertisement. Okay, that brings us to Rule 1260-02-.39, commissions earned by affiliated licensees. This proposed rule is based on an existing commission policy which is more appropriately addressed within a rule. The rule attempts to provide clarification for the payment of commissions earned by an affiliated licensee while working under a principal broker after a number of circumstances occur which result in payment being remitted after the affiliated licensee has ceased his or her affiliation with that principal broker. It is an attempt to provide guidance to individuals finding themselves in these situations and facing concerns of potential discipline from the Commission. Rule 1260-02-.40, electronic records. This proposed rule is based on an existing commission policy, which is more appropriately addressed within a rule. This new rule outlines the procedures that a real estate firm must follow in order to comply with statutory requirements for preserving records in the event that a firm utilizes electronic record keeping. Rule 1260-02-.41, licensees who hold themselves out as a team, group, or similar entity within a firm. This proposed rule provides guidelines for licensees who hold themselves out as a team, group, or similar entity within a firm and attempts to specifically reinforce issues already included within existing law, but clarify those issues more specifically, particularly with regard to licensees who operate in this manner, as it appears to be an increasingly common practice among licensees in order to ensure compliance with the Commission statutes and rules. At this time, I'd like to make the notice of rulemaking hearing, which contains the entire text of the proposed rules and exhibit to the record. And at this time, the Commission will take oral comments from all individuals listed on the sheet. Following oral comments, written comments which have been submitted will be read into the record. Okay, and also before the individuals come up to make comments, it's probably a good idea for you guys to introduce yourselves for the record individually.
Department Hills.
Diane Hills,
Why don't you tell us what city you're from?
Kingsport, Tennessee.
Thank you.
Austin McMullen, Oak Hill, Tennessee.
Marcia Franks, Franklin, Tennessee.
Grover Collins, Lewisburg, Tennessee.
Janet DeChara, Jackson, Tennessee.
John Grease, Farragut, Tennessee.
Gary Bloom from Memphis, Tennessee.
Wendell Alexander from Dresden, Tennessee.
Else before we get started?
Yeah, let me just go a little bit further before we get. The Commission has determined that it will respond to written and oral comments on the record during its January 7th, 2015 meeting prior to adopting the rules with any amendments made by the Commission based on review of oral and/or written comments. Today, Commissioners may ask a commenter to clarify the commenter's position. However, the intent of this hearing is to afford all interested parties the opportunity to comment on these proposed rules and not for the Commission to engage in a dialogue with the commenters. As previously stated, the Commission will consider fully all written and oral submissions regarding the proposed rules and will discuss its substantive responses on the record during its January 7th, 2015 meeting. And at this time, we will take audience comments. Chairman Grease, you can just call the first name on the sign-up sheet, and they can come forward.
Thank you, Ms. Baird. I have Steve Black as the first name on the list. Mr. Black, are you here? Sir, we'll try to set the standard with you. If you will come sit at that chair right there, and before we start the clock on you, if you'll give us your name, your business, and your business address for the record, so we know who we're talking with.
Okay, my name is Steve Black. I'm the broker and operating principal at Keller Williams Realty in Cleveland, and our address is 650 25th Street Northwest, Suite 300, Cleveland, Tennessee, 37311.
All right, Mr. Black, I've got the time is 10:03. You've got 5 minutes, up to 5 minutes.
Thank you, sir. Thank you all for your value, time, and effort in approaching these improvements. We embrace the fact that we can collectively raise the bar of our profession while better serving our clients, customers, and general public. Each commissioner should be commended as well for your tireless progress. One of the world's leading business service organizations, Rotary Club International, developed and operates by a simple four-way test of the things we think, say, or do. 1, is it the truth? 2, is it fair to all concerned? 3, will it build goodwill and better friendships? 4, will it be beneficial to all concerned?
Mr. Black, sorry to interrupt you, but would you tell us which rule you're about to address so we can start with that?
Advertising.
Okay, thank you. Go ahead.
Yeah. I'm here on behalf of the 1,963 agents of the Keller Williams Tennessee franchise system, as well as the other agents of TAR, and we're here to find favor in your decision-making progress in regards to the proposed new advertising rules. So today is all about that, being truthful and fair to all concerned, including the general public of which you are tasked to protect, the 22,000 licensed professionals in the state and their clients, customers of whom they serve. Teams and groups mentioned in 1260.02.41 are developed for many reasons, of which economic and business growth models are only a fraction. Improved customer service is a larger portion of the vision of most top producers as they add administrative assistants, closing coordinators, buyer's agents, or listing specialists. As requested in point 2 of that same rule, all of these licensed agents are paid directly by the principal broker. We want to address the following proposed rule changes in 1260-02-12 advertising. In item 1, we support TAR's suggestion of including sponsorship of charitable and community events. In item 3B2, the firm's telephone number shall be featured in greater size. This new item is one of the most costly changes being proposed and financially impacts every agent and real estate firm in the state. TAR's response noted that under the current rule, only the firm name needs to be the same size or larger than that of the agent, on signage only. Under the proposed rule, the same would be required of the firm telephone number. At $50 minimum per yard sign alone, one can see how the expense would be burdensome to agents and firms alike. While TAR suggests that agents be provided a grace period to be able to budget for procuring new signage, we would like to go a step further by recommending to leave the rule as it is in its current status. In item 3C, TAR's suggested compromise could not be more practical on this issue. The example of ABC Realty and Associates, LLC, accurately depicts fairness in reality. In metropolitan cities and communities alike, we Southern Americans are going to recognize companies and products in the simplest of terms possible. At lunch, are we going to order a Coca-Cola or a Coke? Well, most likely a sweet tea. But the point being, everyone in town does recognize John Smith at ABC Realty, not so much at John Smith at ABC Realty and Associates LLC. The fact that John Smith's name is larger than An Associates LLC does not place the general public at risk. Again, the financial impact to every agent and firm in the state becomes overwhelming. In item 3F3, we agree with TAR's observation that the use of words such as corporation, LLC, Inc., or company might convey a separate legal entity and could confuse the public into believing that this is a separate real estate firm. But as long as it is clear that such an entity is part of a particular firm, they should be permitted to use names such as team, group, real estate, realty, or associates. It stands to reason that the firm broker of those teams or groups, as well as the team or groups themselves, would all have a vested interest to ensure that this TAR recommendation is honored.
Mr. Black, I'm sorry to tell you your time is up. With that said, if you'd like to submit those as written comments, we'd be happy to accept them. So they're
Yes, sir, I have a copy for everyone.
okay. Well, we just need one to staff, to Ms. Smith. I appreciate that. I'm sorry to cut you off, but
That's fine, I understand.
that's what we have to work with. Okay, next on my list is Julie Moss. Moss, if you'll give us your name, company you're associated with, and business address.
Hi, good morning. My name is Julie Moss. I'm the corporate counsel for the Crylike family of companies. My office is located at 6525 Quail Hollow in Memphis. And
Give you a starting, if you're ready to go, I'm going to start you at 10:09.
okay, that'll be fine. I'll just get straight to the rules that I wanted to mention, and they all follow a letter I sent to Ms. Maxwell on August 27th of this year, and outline some concerns mostly for advertising and some clarification on Trex thinking in these rules and how we can interpret them so that we may comply with them. And I do thank the Commission for all of its efforts to maintain the good names and goodwill of real estate licensees in the state. It is much appreciated. First is Rule 1260-02-.122B. And the question is, does TREC interpret this proposed rule to mean that a firm's DBA name as filed with TREC can be used in any advertising in any medium in full stead of the firm's legal corporate name? For instance, our brokerage firm is known to the public as Crylike across the state. And so if quote, Crylike is the DBA firm name, then would TREC find Crylike to be in compliance if it were to advertise in any media as Crylike Realtors, Crylike REO, or Crylike Real Estate Services, whatever further distinction we may want to use within our company to allow the public to know which division they are working with. Secondly, proposed Rule 1260-02-.12.3B1. We have concerns over the amorphous term prominent. What does this mean? Is it going to relate to size? Is it going to relate to position in advertising? So what can we expect to do with that word and how we can use it to comply? And does that include, a licensee's picture? How is that going to be prominent versus the firm name? Next, we've got Rule 1260-02-.12.3B2. And can a firm then have more than one telephone number on file with TREC? Each of the Crye-Leike branches has its own telephone number, which is easily discoverable to anybody who is looking for that branch or any affiliated licensee in that branch. But Crye-Leike can also have, one, firm-wide or company-wide number that we can use. And can then we just have the one number on all the advertising and internet web pages and still not violate this rule instead of having our 60 or 80 or 90 telephone numbers on every web page? Next, we've got Rule 1260-02-.12.3B2 again, and must a firm telephone number be on sold signs? If a licensee's name and phone number are attached on a rider below the sign. That's currently how they are normally used, and as the commission tries to put into play rules of how it has historically talked about signs and signage, just questioning the sold signs. And if Crye-Leike can use, quote, Crye-Leike as a DBA, referencing proposed rule 1260-02-.12.3B2C, if we can use Crye-Leike as the DBA and still advertise Crye-Leike Realtors, and if Crye-Leike, let's say, is 3 inches tall and Realtors is 1 inch tall, can affiliated licensees then have their name be 3 inches tall as in accord with the DBA name versus the Realtors or any other delineator we may choose to use? Rule 1260-02-.12.5A. Again, with the phone numbers, does TREC intend to have a brokerage firm have all of its umpteen phone numbers on every web page, or then can we just also have the one main phone number that we would have on every page? And Rule 1260-02-.12.5C, although we certainly commend the Commission's efforts to help the public and protect them from misinformation and getting Tennessee brokers to keep their web pages and all advertising clear for the public, it still doesn't seem to do any good if we allow syndicated listings to go out to portals where they can then be confusing to the public.
Ms. Moss, I'm going to have to call time on you.
Thank you.
We have those comments in writing as well, is that correct?
Yes, sir, I believe you do.
Thank you very much for your presentation. Bill Haggard.
I'm going to yield my time just for sake of efficiency.
So you don't choose to be heard?
Correct.
Thank you, Mr. Haggard.
Yeah.
Scott Troxer. Morning, Mr. Troxer. Give us your name, business, and business address for the record.
Sure. It's Scott Troxel. I'm with Keller Williams Realty here in Nashville. Have been an agent since 1993.
Let's start you at 10:15.
Okay, that's fine. I've had my broker's license since 2002, and I've served as managing broker at 2 different firms. And I'm currently not the managing broker at our firm. I just wanted to comment on just a couple elements, and they're mostly related to teams. I applaud the commission's efforts to provide greater clarity as it relates to prominence of the host agency in marketing, and I understand the commission's desire to provide better framework for teams to be managed by their broker. I wanted to speak as far as the section concerning advertising and the use of teams, groups, and such. I do feel that the restrictions related to teams in the advertising section are a little bit of a knee-jerk reaction and basically take a 15-year step backwards. Restricting the naming and identity of teams is counter to established trends in the national real estate industry. If the rulemaking related to advertising, as far as prominence of the company, the agency, the host agency, if you want to call it that, if that is effective, then that should be enough to establish that teams are not independent entities or brokerages. Much of that section related to teams is redundant if the advertising section is effective. And then as far as the element related to teams that they must be on site, agencies are not required to have their agents on site, and yet these rules require that a team or group has to be on site. My experience is that the greater problems with non-compliant behavior is with the individual agent who only enters the office to pick up their commission check, that they're not participating in the office, they're not as active in CE, they're not learning best practices from their fellow agents. My experience is that agents that lead teams continue to seek training and pursue higher levels of learning than most agents do. And their training benefits the consumer and the agent on the other side of the transaction. So I just encourage you that as it relates to teams and groups, that we not take a step backwards. And those are my comments.
Thank you, Mr. Troxel. Jim Gibbs.
Mr. Chairman, I appreciate the opportunity to speak.
Don't want to talk to us today?
Not today.
Mr. Gibbs, a well-known educator in Middle Tennessee who generally has an opinion he likes to share with us, but...
I have opinions, but the opinion has spoken for me today.
All right. Thank you, Mr. Gibbs. Andy Brown. Morning, Mr. Brown.
Morning. My name is Andy Brown. I'm the principal broker of RE/MAX Elite in Brentwood, Tennessee, 278 Franklin Road, Suite 190.
All right, sir, I'm going to start you off at 10:18.
My first comment is according to advertising. And from what I've seen in commission meetings that I've attended and seen, the way a complaint is filed, it's anonymously filed. I don't know if you find out after the fact or before, but a large percentage of these advertising complaints are agent to agent. So in the commission's responsibilities, as I understand, is to protect the consumers, and that's what you sit and do. When an agent goes on and has a bad transaction with another agent, and then decides that they go out and they find some reason to complain of another agent. And believe me, I understand in reading through the backlogs that there are a lot of complaints that come in on advertising, and there's a lot of violations on advertising that are there. In recent changes to the fines have been increased drastically in those advertising things that are there in effort to curb those violations, and I understand that. My question is there a way for agent-to-agent complaints to kick that to the boards that are there? Is there a way to identify when that happens to where if you're protecting the consumer, an agent complaining against an agent is not a complaint that's protection of the consumer that's there? The other that I look at is with regards to teams, and changes those rules that are in effect by limiting the business practices that they're there. If you want to regulate or put regulations involved or have supervision of those teams, totally understand the education and reinstating education requirements that are there, because I believe in education. I think all of our agents should have education. In doing so, when the fines come down, whether it be advertising or the new team regulations that are there, a lot of times as if the principal broker is involved as well. And I understand that. They're responsible for, supervising those folks. Are there better defined rules on what you would say supervision is? Because if I hold 5 different classes a month, but I have independent contractors and I can't require those folks to be there, am I supervising my agents at that point in time? That's all I have at this point.
Thank you, Mr. Brown. Appreciate you coming down. Todd Scholler. Morning.
Good morning, sir. How are you?
Fine, thank you. If you'll give us your name, business address, and business for the record.
My name's Todd Scholler. I'm an attorney. I'm from Gallatin, Tennessee. I'm with Smith, Scholler, Milliken Attorneys. I have the pleasure and distinction of representing several boards, and yes,
Record, I'm going to start you off at 10:22.
Okay.
Okay.
Several boards, and also have the pleasure of going around the state and educating realtors, which has been a real honor for me to do. A lot of what I was going to speak about has already been talked about, but some of the things that have come up in classes when I talk about these rules are some concerns about some of the vagueness of some of the verbiage. For example, in 1260-2-.12, something that stuck out to me is the incidentally advertising language. And then it goes on to say hats, pins, notepad, T-shirts, name tags, and the like. I'm not sure what "and the like" is. And several people have raised questions about specific things. Is my name on a scoreboard at a baseball park, is that incidental? I'm not really sure. Other situations, sponsoring charity runs and their signage, is that incidental? At one point in time, there was a slight distinction between signage on property that was for sale, literally for sale, and property that are signs that was just merely advertising the licensee. I personally like that distinction. I do think there's a difference. And although we've gotten away from that distinction with the proposed rule, now we treat all of these the same. One other thing that raised some concern for me was with regard to 1260-2-.12, Section 3B, specifically talking about advertising under the direct supervision of the broker, conspicuously listing the firm name. It goes on to say in subpart 2, the firm's telephone number shall be featured in greater size and/or prominence. So I don't know what that means exactly. I guess it's our choice as to whether it's greater size or prominence, which raises the question to me, what is prominence? Is it the biggest? Is it the brightest? Is it the first listed? I'm not really sure. And I want to be able to advise people that are truly trying to comply with the rules as to what exactly does that mean. And that has been a serious concern raised. Beyond that, I really don't have any other comments that haven't been already addressed. And I know that TAR has given you an extensive and a list of their concerns, and I actually have read those, and for what it's worth, I agree with most of their concerns as well.
Thank you, Mr.
So
Scholler.
much. Appreciate you.
Appreciate you. Monty Moore, I think, M-O-H-R. Is that? Thank you, Mr. Moore. I can hardly read the next two signatures, but I think Jessica Averbach. So you waive your opportunity. Thank you. And then I have Stacy, I'm sorry, Baudour, Stacy. I'm sorry. Thank you, Miss. How do you say your last name? Booker. It's Booker. Thank you. All right, ladies and gentlemen, that concludes the list of people I have signed up to speak on this. So that will conclude the oral comments. However, we are going to read into the record the written comments that the staff of Tennessee Real Estate Commission has received. If some of you have written comments that you would like to submit, you've got until the end of these being read into the record to do that. Please let us know. We want to give everybody an opportunity to speak what they want to say. Yes, ma'am.
At this time, I'm going to read the written comments that were submitted to the commission office prior to this rulemaking hearing.
That's perfect.
There are three different sets, so I'll try to just identify who it came from and give you as much information as possible. The first written comment that we received came from David Watson, broker with Beck and Beck Incorporated. It says, with regard to Rule 1260-02-.024, I would prefer it be spelled out that the permission, I would prefer it be spelled out that the permission to take a listing is to be in writing. Thanks. So that one was short and sweet.
Are they all like that?
No,
Okay.
but I'll try to be quick. You can cut me off at 5
No, I
minutes.
won't cut you off.
The next written comment we received was from J. Russell Farrer with the law offices of Farrer and Bates. It says, I serve as general counsel for the Tennessee Association of Realtors, Inc. We had an opportunity to review the proposed rules and rule amendments to be discussed at the November 5th rulemaking hearing. Based upon the commission's review of the proposed rules, TAR would like, do you say TAR or TAR? Okay, sorry, I'm new to this. TAR would like to ask for your consideration of the following comments. These comments should be considered as TAR's comments for the rulemaking hearing on November 5th, 2014. Rule 1260-2.02, termination of affiliation. Section 1, termination of principal broker's duty to supervise. Within Section 1 of this rule, a principal broker's liability for the supervision of an affiliate terminates upon the Commission's receipt of the release form. However, the rule does not define what constitutes receipt by the Commission of the TREC 1 form. This must be clarified by the Commission so that brokers fully understand when their liability ends. Furthermore, there will be inevitable computer glitches and fax machine malfunctions, and therefore the Commission should establish what constitutes receipt by the Commission and how this can be proven in the event that a dispute arises. Section 3, receipt of TREC 1 form. Within Section 3, agents and their new principal brokers are permitted to transfer an agent's affiliation online. In Part 3B, a licensee's transfer will be effected as of the date it is completed online, as long as the new principal broker submits the completed and signed TREC 1 form and it is received within 5 business days of the online submission. Again, TREC should clearly clarify what constitutes receipt by the Commission. This could be interpreted as the date and time it was faxed or emailed by the broker, or it could be interpreted as the date and time the fax or email was received by the Commission. TAR maintains that it should be the date and time that the broker either faxed or emailed the form, which can be verified via a fax confirmation page or via the date and time on the sent email. Number 2, liability of affiliate in the event that TREC 1 form is not timely submitted by broker. Another issue arises within Section 3B of this rule. It is unclear as to whether the affiliate who is attempting to transfer firms would be held liable for practicing real estate during the 5-day grace period in the event that the new broker fails to send in the completed TREC 1 form timely. This would unfairly subject affiliates to sanctions by TREC when the failure to timely submit the form lies with the principal broker and not the affiliate. In the event that such occurs, the principal broker should be the only agent subject to discipline by TREC. C, listing and buyer representation agreements following termination of affiliation. In Section 4, a licensee is not permitted to take listings secured by the firm with him if he terminates his affiliation with the firm without the approval of the principal broker. The rule under consideration could be amended to include buyer's representation agreements secured by the firm. Another issue that can be clarified by the Commission is what happens in the event that it is the principal broker terminates his affiliation with the firm. TAR avers that in that situation, the departing principal broker must obtain the permission of the firm owner prior to taking a listing or buyer's representation agreement with him. Rule 1260-2-.09 deposits and earnest money, definition of trust money. Section 1B1 defines trust money as money belonging to others received by a licensee who is acting as an agent in a real estate transaction. However, agents do accept funds from customers when acting in a facilitator capacity. Therefore, the rules should be amended to read, 1. Money belonging to other received by a licensee who is acting as an agent or facilitator in a real estate transaction, or B. Accept trust money. In Section 5, the use of the phrase accept trust money is troublesome. Currently, the rule reads as follows. Where a contract authorizes a broker to place funds in an escrow or trustee account, the broker shall clearly specify in the contract. By changing the verbiage, it appears that any time a broker accepts earnest money, even if it is to pass it along to a third-party escrow agent, the broker must state the terms and conditions under which the funds are to be distributed and the name and address of the person holding the funds. In situations where a third-party escrow agent, as is being done more commonly now, especially in commercial transactions, this would be addressed in an escrow agreement between the parties and the escrow agent. TAR would ask TREC to recommend retaining the previous language with the substitution of trust money for funds, such that the rule would read, where a contract authorizes the principal broker to place trust money in an escrow or trustee account, the broker shall clearly specify in the contract. Name and address of holder. In the current and revised rule, Section 5B requires the name and address of the person who will actually hold the funds. TAR would suggest amending this to require the name and address of the firm holding the funds, since most trustee and/or escrow accounts are in the name of the firm. With regards to interpleader, in Section 9, the proposed rule requires distribution of the funds within 21 days absent a compelling reason. TAR would suggest that this be amended so that the requirement is that the funds be dispersed or turned over to an attorney for interpleader within 21 days. Brokers cannot force an attorney to timely file the interpleader. Therefore, the requirement of the rule should mirror the actions which are under the control of the broker. Rent and security deposits. In Section 12, the proposed rule requires that all trust money received and held which relates to the lease of property must be held in one or more separate escrow or trustee accounts. The manner in which this is drafted creates confusion as to whether this applies to security deposits, rent payments, or both. The current version of the rule only applies to security deposits. This is the same as required pursuant to the Uniform Residential Landlord and Tenant Act, Tennessee Code Annotated 6628301A. TAR avers that the requirements of the TREC rules should not be more strict than that of state statutes. Without clarification, the rule as drafted could result in requiring a firm to have at least 3 different escrow or trustee accounts, one for escrow money, one for security deposits, and one for rent payments. TAR avers that the rule should be clarified to only require that security deposits be held in a separate trust or escrow account as is required under the current rule. Rule 1260-2-.12, Advertising, Section 1, Sponsoring of Community Charitable Events. In Section 1, things such as promotional materials that incidentally advertise a licensee, such as hats, pens, T-shirts, notepads, name tags, and the like, do not constitute advertising. TAR would suggest that this same exception to the rule be made for agents who are sponsoring charitable or community events. Often the event coordinator or organizations limit what can be placed in an advertisement, banner, etc., and the firm name and telephone number may not be included. TREC should not prevent sponsorship of these worthy events merely due to the difficulty in complying with TREC rules. Definition of prominent. In Section 2B, the proposed rule states that the firm name and telephone number must be conspicuously displayed and that the firm name must be the most prominent entity featured within the advertising. This needs to be clarified to state exactly what prominent means. The Commission could interpret this to mean that the firm name must be in a particular place in the advertisement, mentioned more times in an audio or visual advertisement, mentioned more times in a magazine spread, etc. This must be clarified with specifics included so that agents can abide by the new rule. The same is true for the telephone number. TAR would suggest that multiple examples of advertising which would be considered compliant as well as non-compliant as further explanation. Telephone numbers. In Section 2B, there are additional requirements that have not previously been enforced. For example, under the current rule, only the firm name had to be larger than that of the agent on signage only. However, under the proposed rule, the same is true for the firm telephone number. In addition, these requirements are being applied to all advertising, not just signage. This means that advertising which currently meets the requirements of the rules will be in violation. Agents must be provided a grace period in order to budget for and procure new signage, new television ads, new billboards, new car wraps, etc. TREC must understand that these items cost significant amounts of money and cannot be corrected overnight. To immediately require this will place large financial burdens on licensees currently in compliance. TAR additionally raises the issue of the meaning of prominence as it pertains to telephone numbers. Section 3, TAR requests that TREC clarifies whether all the subparts of Section 3 apply to all advertising or if it only applies to signage. Different size fonts utilized in firm name. There is an issue with the interpretation of the font size requirement. There are many real estate firms that have different size fonts within their name as registered with TREC. For example, the firm name is ABC Realty and Associates, LLC, as registered with TREC. The manner in which the name appears on signage is ABC Realty and Associates, LLC. Under the proposed rules, the name of the agent must be the size of and Associates, LLC. However, everyone in town recognizes the firm and often refers to it by the name ABC Realty. TAR asks if a compromise could be enacted to allow for such type of advertising. If the majority of the firm name, or at least the part of the firm name by which it is recognized in the community, is in a different size font than the remainder of the name, the agent's name should be the same size or smaller than that portion of the firm name. Franchise names. In Section 3F2, there is a requirement that all advertising must include the firm name and not just the franchise name. This would be impossible for large franchise or companies with multiple offices. The requirement that such websites include each firm name would create a great hardship and a website that would be confusing. This should not be a requirement for the franchise website, only the individual office websites. Use of the word group in team, group, similar entity name in Section 3F3, as well as other places in the proposed rules. TREC references licensees who hold themselves out as a team, group, or similar entity. However, in that same section, TREC prohibits these agents from using the word group in their name. This prohibition is inconsistent with the other proposed rules and should be deleted completely. Existing team names. Many teams, groups, similar entities have existed for quite some time and have spent a significant amount of cash and resources branding their team, group, similar entity. Now they will have to essentially start over to brand a new entity simply because one of the prohibited words such as real estate, realty associates, and group is in their name. As long as it is clear that such entity is part of a particular firm, they should be permitted to keep their name. Furthermore, while TAR recognizes the need to differentiate between a firm and a team, group, similar entity, several of the prohibited words should be considered for deletion from the rule. While the use of words such as corporation, limited liability company, incorporated company, LLC, corp, and Inc. convey a separate legal entity and could confuse the public into believing that this was a separate real estate firm, other words contained in that list would not necessarily do so, such as real estate, realty, and group. As long as the advertisement is clear that the team, group, similar entity is part of ABC Real Estate Firm, these words should not be prohibited from the team, group, similar entity names. Team names. The phrase that would lead the public to believe that those licensees are offering real estate brokerage services independent of the firm and principal broker in Section 3F3 is vague. TAR respectfully requests that this be clarified and explained in detail so that agents across the state understand the requirements of the rule, as our licensees do not intend to change the perception to the public. TREC should present several sample advertisements that are both compliant and non-compliant so that agents can understand what will be acceptable, especially since there are so many changes under these proposed rules. Photographs of teams. Section 3F4 seems extreme and is not needed and accomplishes nothing. It does nothing to protect the public. It places a burden on teams, groups, similar entities to redo any existing advertising they may have, which includes photographs. TAR opposes this addition to the rule. Website links. Section 3F5 appears unclear. Please provide a firm definition of what is being prohibited and/or examples of cases which would be considered by TREC to be in violation. This will assist both the public and real estate licensees. Cooperative advertising group. Section 4 makes reference to cooperative advertising groups. However, cooperative advertising group is not defined in the Brokers Act or TREC rules. If the Commission cannot provide a definition to this entity, TAR would suggest that the reference to cooperative advertising groups be removed from the rule as all it does is create confusion among licensees. Internet advertising. Section 5A requires that the firm name and telephone number appear on each page of the website. As previously discussed, this will be very difficult for large franchises or large companies which have many offices in Tennessee. If there is a single franchise or company website, it will be very difficult to put every firm name and telephone number on every page. The end result could create more confusion on the part of the public. This should be considered so that these types of websites would be excluded from this rule and only make it applicable to individual offices, agents, and/or teams, groups, and similar entities.
Do me a favor and take
Sure.
a break, take a drink of water.
Okay. Sure. I'm ready. Just gonna keep going. Social media. Another area where TAR asks for clarification is how Section 5A applies to social media and other emergent trends. In the past, the Commission discussed that it might be sufficient to post a link wherein the firm name and telephone number would be provided given the limited number of characters available in some social media and applicable avenues. If this is permissible, this should be made part of the rule. Agents must be advised as to what will and will not comply with the revised rules. Rule 1260-2.39, commissions earned by affiliated licensees. Part A, when a commission is earned. TAR hopes TREC will consider that this rule could be amended to clarify TREC's long-held, unwritten position that it considers a commission to be earned by a licensee at the time that the property goes under contract. This is not clearly stated anywhere in the TREC rules or the Brokers Act. Rule 1260-2.41, licensees who hold themselves out as a team, group, or similar entity within a firm. Part A, licensed assistant. In Section 2, it needs to be clear in the rule that a licensed assistant does not have to be compensated via the principal broker when that licensed assistant is paid a salary as an employee. The licensed assistant can be paid by the licensee for whom the assistant works. And I think that addresses all of the specific rules in that response.
Who's next?
Okay, we have one more, right? One, possibly two. This response comes from Philip Cantrell, CEO of Benchmark Realty LLC.
Can I get a clarification on that letter? I've seen it.
Okay.
A large portion of it talks about issues that are not part of this rulemaking hearing. I'd like to get direction from counsel as to whether or not that needs to be read into the record, or because it's written comment, it doesn't matter what it says, it has to be read into the record.
Now, I mean, if it doesn't address any of the proposed rules that we're talking about, it doesn't need to be addressed right now.
At some
I mean,
point, you'll get
that's-
to a section there referring to continuing education,
Okay.
which is not in front of us today.
Okay.
So unless you direct us otherwise, I don't think you need to read that in.
We'll leave that out.
Okay.
That doesn't need to be addressed.
Okay, thank you.
Okay. Let's see. Just as, I guess, a way of introduction, Mr. Cantrell is the founder and CEO of Benchmark Realty LLC. Says, I would like to make some comments specifically regarding the proposed signage rule changes and the team name rule changes. Relative to signage, regrettably, it seems there are indeed repeat offenders of the current rules who obviously consider TREC fines to just be a cost of doing business. The signage used by a few agents comes to mind since it requires a person to stand no more than 3 inches away to be able to actually read the company name. The current rule seems adequate to address this type of presentation, so it really appears more a question of adequate enforcement and proportionate penalty than one of a need for additional rule creation. For those of us who comply with the current rules, the verbiage of the proposed rule change would cause undue hardship because it would force the replacement of many currently compliant signs. This is especially true when the company name utilizes multiple font sizes, as ours does. They've attached to this letter an image of a couple of options from which we recommend our agents choose for their yard signs. Those are just attached there for your review. The other difficult part of the proposed rule change relates to team names. Again, I acknowledge there are gross offenders out there. However, painting with such a broad brush captures many who are already meeting current rules and require those agents to rebrand themselves. Our policy and procedures manual clearly spells out in reinforcement of TREC rules that all advertising must be approved by the principal broker. That specifically includes the team name and its presentation. Through that process, we have allowed teams to name themselves within the current TREC guidelines, and we always require the team name to include the words, in parentheses, of Benchmark Realty LLC, in a specific effort to avoid confusion in the public's mind as to the name of the broker. Many of our teams have spent incredible amounts of money branding themselves, and varying from the current rules would again create a sizable economic hardship on them. With all that said, though, we must recognize that the consumer will only believe what they want to believe, hear only what they want to hear, and will never actually read all the details of any agreement or advertisement placed in front of them. Combine that with the common lack of personal responsibility in today's society, and there exists a situation where it is simply impossible to create a sufficient volume of rules to cover every conceivable possibility. Of course, you are closer to the problems than I am, but it really seems to me that in these two areas we already have sufficient rules on the books, and that the issues won't be solved by creating additional and more complex rules. I would advocate that these issues can only be solved by more stringent enforcement of those rules we already possess. I would propose the only global solution for solving the core problem is to forcibly raise the level of professionalism within the industry, point blank, raising the entry barrier to our industry while at the same time stiffening the requirements for remaining in the industry is a much more sustainable long-term strategy for protecting the customer. Given TREC's primary mission, it clearly appears that the best way to protect the consumer is to eliminate those who do not operate in a professional manner. My encouragement then is to raise the requirements to a point that only those who see this as a genuine career would be willing to pay the price, and I don't just mean monetarily. It is the only long-term strategy to ensure that the agents consistently behave in a professional manner, fulfill their contractual obligations, and thereby protect the consumer. With those comments in mind, I would propose consideration of the following 5 changes. Oh, so we don't need to read these. Okay.
Just for
Okay,
the
yeah, it
record,
appears-
those 5 changes
Right.
all had to do with continuing education.
So
Okay.
the next 5 changes are on continuing education, which are not part of the proposed rules, so we won't read those into the record.
And examination, and initial examination.
Right, unrelated to the rules in front of us today. Now, so you guys might have accepted 1 or 2 written comments this morning. Is it appropriate that they be read in the record at this point, counsel?
We have been advised to go ahead and read this one because this person didn't speak. So this is the last one? Okay, this is the final one. This is from Aaron Armstrong, affiliate broker with Keller Williams Realty. Let's see. It says, I have had an opportunity to review the proposed rules and amendments in detail. I understand TREC's main focus is to protect the consumer. It is with great respect for TREC's role in the process and a mutual concern for the well-being of the consumer that I ask for your consideration of the following comments. It says, I support and agree with all comments and opinions the Tennessee Association of Realtors submitted on September 22nd, 2014. TREC Rule 1260-02-.41, licensees who hold themselves out as a team, group, or similar entity within a firm. Section 1 prevents agents from being a part of a team or group unless they are affiliated with the same licensed firm and at the same physical location. I asked TREC to amend this rule and allow for agents at different licensed firms to advertise and market as being part of the same team or group so long as they adhere to all advertising rules and they have permission to do so from their own principal broker. Please consider a scenario where, due to a team or group's online presence, radio or television advertisements, referral networks, or other common lead sources, that team or group consistently receives inquiries from consumers in a location that is outside of the normal service area of the primary location of that team or group. For the purpose of this example, let's assume a team or group with a primary location in Nashville generates a significant number of requests from consumers in Murfreesboro that wish to utilize their services. It's common practice that said team or group might refer that consumer to another licensed agent whose primary location is in the Murfreesboro office of the same franchise company. If it is a high volume of consumer requests and the agents from the two different offices want to formalize an ongoing referral relationship, why should they be prevented from advertising as being part of the same team or group? At the very least, could they not advertise as, in quotations, insert name of team or group, Nashville, and, in quotations, insert name of team or group, Murfreesboro? Doing so would allow the team or group to provide a higher level of customer service to each client by having a local market expert serve the consumer. Alternatively, not allowing this encourages agents to work further outside of their general service area in locations that they may not be as familiar with. I would fully expect that any market be required to adhere to all advertising rules, and each agent would have to receive approval from their own managing broker.
Thank you.
Mr. Chairman,
Yes, ma'am.
do we have a copy of that one?
We will. I
Okay.
was going to explain that all of these comments, both oral, once they're transcribed, and written comments will be given to the law department, who will summarize those with the points that each individual is trying to make, and those points will be what we discuss and make decisions on in our January 2015 meeting. Is that the last written comment that you have?
It is.
Does anybody have any other written comments? It's last call. All right. The comment period for this rulemaking session is hereby ended. It's 9 minutes till 11 o'clock on November 5th. We have one more piece of work that we have to do related to these rulemaking hearings today. Ms. Breeden, you want to just tell us what it is we need to do?
Okay, that concludes the comment period of the rulemaking hearing. At this time, we will continue with the economic impact statement and the statement regarding the projected financial impact on local governments for these proposed rules. I have included the considerations for the economic impact statement as well as the impact on local governments in the handout, which each of you have, along with recommendations which I have prepared as a starting point for discussion as to each of the considerations. The Commission will need to adopt responses to each consideration by motion.
And is it your intent to include all the rules in each motion, or are we going to do each rule separately?
I think we probably need to do each of the, adopt a response for each consideration separately.
What, is it a copy of something we already have?
That's the economic
I've got an
impact
extra.
statement.
I don't have that.
Oh, yeah, you will just need to do it. We'll just need to do this for the rules that that it impacts, not.
Okay, so I think we can, my sense is we can do an economic impact statement for the rules collectively, and if they don't apply collectively, we can break out a particular rule and talk about it.
Correct.
Okay,
Yes.
perfect. Okay.
Can we share?
All right, is the procedure for you to read it into the record?
Yes.
Okay.
Okay.
Let me just interrupt. This, for those of you who've seen or heard enough, this is a formality we have to go through. If you're inclined to leave at this point or stay for today and tomorrow, you're welcome to, but please be quiet if you're on your way out. Okay, Ms. Breeden.
Okay. Pursuant to the Regulatory Flexibility Act, TCA 45401, as part of the rulemaking process, each agency must prepare an economic impact statement as an addendum to each rule that is deemed to affect small businesses, which shall be published in the Tennessee Administrative Register, filed with the Secretary of State's office, and made available to all interested parties, including the Secretary of State, Attorney General, and Reporter, and the House and Senate Government Operation Committees. This requirement is found at TCA 45403. The statement shall include the following. Number 1, the type or types of small businesses and identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule.
Commissioner McMullen.
We're going to make a motion with respect to all of the rules at once, is that?
Yes,
that-
but you may want to break out a particular rule.
Okay. Mr. Chairman, I move that we adopt the following economic impact statement with, for the rules that are under consideration with respect to point 1. I would recommend that we adopt the statement that the proposed rule that is expected to result in a potential cost to small businesses is the proposed amended Rule 1260.02.12 regarding advertising. According to the Tennessee Code, Section 4-5-10213, the term small business is defined as a business entity, including its affiliates, that employs 50 or fewer full-time employees. It is estimated that there are 3,898 licensed active real estate firms in the state of Tennessee, and that most of these firms are, in fact, small businesses under that definition. However, it is recognized that in many cases, individual licensees, rather than the firm, bear the cost of advertising. It is estimated that there are 24,429 licensed active affiliate brokers and brokers in the state of Tennessee who could be impacted by the potential cost of this rule change.
Is that, we need a motion.
Yes.
So my motion would be to adopt that statement.
Second.
I've got a motion by Commissioner McMullen, seconded by Commissioner Collins, that the statement as read into the record by Commissioner McMullen be adopted. Is there discussion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes. Number 2, Ms. Bree.
Number 2, the projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record.
Mr. McMullen.
Mr. Chairman, I would move that with respect to the rules that we're considering today, we adopt the following statement in response to point 2 of the Act, which is that it is not anticipated that compliance with the proposed rule will result in costs that are of a reporting, record-keeping, or administrative nature.
Second.
I have a motion by Commissioner McMullen, seconded by Commissioner DeChara, that statement as read into the record by Commissioner McMullen be adopted. Is there discussion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ms. Baird.
Number 3, a statement of the probable effect on impacted small businesses and consumers.
Mr. McMullen, do you have a thought on this one?
I would propose that we adopt the following statement with respect to point 3 for the rules that we're considering today, and that is that the proposed rules are expected to assist with the protection of the welfare and safety of the citizens of the state of Tennessee, and that is the probable effect.
Second.
Seconded by Commissioner Franks. You've heard the motion offered by Commissioner McMullen, seconded by Commissioner Franks. Is there discussion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ms. Baird.
Number 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small businesses.
Commissioner McMullen.
If I could ask legal counsel, I mean, considering that, we have heard comments and there could be changes as far as what we ultimately adopt, would it be appropriate now to address those alternatives in a statement, or should we delay consideration of the statement, or what's your recommendation on that?
I would suggest that you adopt a statement that you could do now with the information that you have available, and that if that changes in the future at the next meeting, adopt a new statement. But I would encourage you to do it now in case that doesn't happen in the future.
Thank you, Mr. Flandorf.
Mr. Chairman, I would move that we adopt the following statement with respect to point 4 of the Act for the rules that we have under consideration. And that is that the Commission has considered the burden and cost alternatives and does not believe that there are less burdensome, less intrusive, or less costly alternative methods known at this time to achieve the purpose and objectives of the proposed rules, but we'll consider the comments that have been made and determine if the same objectives can be achieved in a less costly and burdensome way.
Second.
Motion, you heard the motion from Commissioner McMullen. Commissioner DeChara has seconded that motion. That motion, is there discussion on the motion? All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 5, please.
Number 5, a comparison of the proposed rule with any federal or state counterparts.
Mr. McMullen.
Mr. Chairman, for the rules that we're considering, and in response to point 5, I would recommend that we adopt the following statement. There are no known federal counterparts to these rules. For many of the rules, there are no known state counterparts as well. Other states are known to have regulations or rules containing provisions that are similar in nature to the provisions that are included within the proposed amended Rule 1260-02-.12 regarding advertising, and those include Georgia Rule 520-1-.09, Louisiana Section 2501, Nevada NAC 645.610, and NRS 645.315, North Dakota Rule 70-02-03-02.1, and Washington WAC 308-124B-210.
Commissioner McMullen moves that that statement be adopted. Commissioner DeChara now seconds that motion. Is there discussion on the motion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 6.
Number 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule.
Mr. Chairman, for the rules that we're considering, I would move that we adopt the following statement in response to point 6 of the Act, and that is that any possible exemption of small businesses from these rules would result in significantly less protection for the citizens of the state of Tennessee based on the definition of small businesses as provided under the Tennessee Code Annotated.
Second.
I have a motion by Commissioner McMullen to adopt a statement he read into the record, and it was seconded by Commissioner Franks. Sorry, Janet.
That's okay.
All right. Is there discussion on the motion? Hearing none, let's vote. Those in favor of the motion, vote aye. Aye. Those opposed, no. The motion passes unanimously. Ms. Baird,
We just have one more
Yes.
thing. Also pursuant to TCA 45228, a simple declarative statement must be adopted regarding whether the rules may have a projected financial impact on local governments.
Commissioner McMullen.
Mr. Chairman, I would move that we adopt the following statement concerning the rules that we have under consideration in response to the requirement in Tennessee Code Annotated Section 4-5-228 regarding the projected financial impact on local governments. And that is that these rules are not reasonably viewed as having a projected financial impact on local governments.
Heard the motion from Commissioner McMullen, now seconded by Commissioner DeCharo, moving that that statement he read into the record be adopted. Is there discussion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Ms. Baird.
That concludes this rulemaking hearing. Thank you for being here today.
Thank you for your hard work on that for sure. And for those of you who are not staying for the rest of our meeting today and tomorrow, thank you all for coming, complying with our guidelines, and we wish you safe travels on the way home. The commission is going to take a lunch break. For those of you who are coming back, we'll be back in session at about 12:15. So hurry back. We're during the break that maybe some of y'all that are here for credit or required to be here didn't sign the right sign-in sheet when you came in. So for you to get credit or to satisfy any requirements you might have, I need to make sure that you've signed in on the right sheet. And we'll assume that if you didn't this morning, that you will, and that you were here this morning. But we've got an employee who's a stickler for making sure that it's done correctly. So please, please make sure you're signed in.
That one back there at the back of the room.
All right, with that said, it's 12:15, and I say, let's get started. All right, we are to the education report, Ms. Maxwell.
The education report, hopefully everyone received a copy of that. There was only a couple of courses that I put under the requiring discussion, and it was really more so that the commission, again, would know that these courses were out there. There were two courses by the NAIFA under courses requiring discussion on the second page. One was today's FHA and VA, and then one was defensible appraisal practices. Both are very, very comprehensive and courses, but they are strictly appraisal courses. I mean, they deal with basically from the lender point on. So as I say, I just wanted to, I mean, they both, as I say, were very comprehensive, looked like they were good courses, contained a lot of information. I just wanted the commission to know that they were strictly appraisal-related courses as opposed to real estate courses, and so that's why they're under the discussion topic. All the other courses and teachers looked like they were fit into the requirements set forth in the rule, and the teachers all looked like they were qualified to teach the courses. So I would recommend the commission approving them. If there's a question about any of them, I'll be happy to answer it.
I make a motion, we approve courses N1 through N7. Second.
We have a motion by Commissioner DeCharo, seconded by Commissioner Franks, that courses N1, excuse me, through N7 be approved. Is there discussion on the motion? All right, I hear no discussion. Let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously.
Mr. Chairman?
Yes, sir.
McMullen abstains on N1.
Oh, yeah. Aren't you a previously approved instructor?
Got that seedy character on there.
I don't know.
Has he been
I don't know what I
fingerprinted?
He is indeed a previously approved instructor, but this is a course that I guess he's in part instructing.
Got it. All right.
Thank you.
Thank you, sir. Does that conclude the education
That
report?
concludes the education report. The renewals, just the course renewals and instructor renewals seem to be, have reached their maximum capacity at about 75 to 80%, which is about the way it usually runs. So I don't anticipate that we'll get many more renewals at this point. If the commission would like, we can make a list of all the courses that have come in for renewal and send them to the commission for their final approval for renewal, since they'll expire on 12/31 of 2014. So we could do that before the meeting next month, so you have an opportunity to look at them. I'm just listing by name and instructor so that you can see that, if that would, so that would make it probably easier for the commission to make a decision about approval. These are all courses that were previously approved and now are, they just want to renew for the next 2 years.
Mr. Chairman, I think that's good, and but I would like for us to have a discussion about education and how it's being delivered at some point. I don't know what time that would be appropriate, but sometime at our next meeting if we could.
What topics would, what do you?
I would like to talk about especially the affiliate broker requirements, online versus in a classroom. And I'd also like to just have some discussion about hours, too, required hours.
You mean like changing, it would take a statutory change
Would
to
it?
change those. I mean, to change the number of hours. Because
Yes.
it's provided for in the statute as a condition precedent to renewal.
Okay.
I mean, I'm just telling you that just so you have that information.
Okay.
But that's fine. I just kind of want to find out exactly what you want to talk about so I can get you all the information that you need.
Okay.
To talk. So the affiliate brokers, you just want to talk in general about the type of.
I would like to
education
talk
that's offered?
about online classes versus sitting in a classroom for affiliate brokers.
For the pre-license or for just in general?
Pre-licensing,
For
and-
pre-licensing in particular, okay.
The A and B, and then the, what is the class called that you take after you pass your exam?
Course for new affiliates.
Yes, that one also.
Okay.
So Commissioner, in particular, how it's delivered or the content?
More on how it's delivered. I have a daughter who just got her real estate license, and so I've been able to see that pretty close up. I'm concerned with people taking online classes versus sitting in the classroom. I think it's very easy for people to take those classes for you. She had a friend who did it with her also, and once they passed their exams, their workbooks were exactly the same, their tests were exactly the same. And I just have concern because they heard that people were passing those around.
That's education.
That's what I'm saying.
Learn how to pass the test.
Oh.
Well, one of the things too.
It's
I
easy
think-
to cheat, is what I'm saying.
I think one of the things too is probably content. I'd like to talk about while we're doing that, because I also know that a lot of the schools are just bringing in like a home inspector, and the home inspector spends several hours and they're not really getting what they are intended to get.
Except for
They
the
have-
CNA or all, or?
All of them, but.
I mean, you're talking about specifically the 90 hour, like 60
Yeah.
and 30? Okay. The
Yeah.
pre-licensed courses.
Right.
While you're talking about all that, don't forget to talk about the contracts that they're telling you got to use.
There you go,
I
open
don't
it up
know
another
that,
damn.
are they telling?
No, they're not telling you have to use
They
it.
don't tell you what contract you have to use in the classes.
That's a rule
Not
in
in-
my office, but.
Not in the
When I
new.
sent young Bynum to school, and he come home, they were preaching the contract, they got a test on, had to fill those things out. Now, you don't tell me about all of them.
On the new affiliate ones?
I don't know
On the
whether-
new affiliate?
Yeah,
ones?
that-
Been 2 years or 3 years ago.
That's
That
probably
is
the course for
that
new
is-
affiliates.
That is the course for new affiliates, and they do have a TAR contract. There's 3 of them that they have to fill out. I don't know, I can find out. Meanwhile, did they tell her you have to use a TAR? That's something I require in my office, but it was a TAR, 3 of them that they had to fill out, and they were graded on. But, I mean, you got to use some kind of contract to grade them on writing a contract.
So Eve, do you think this is a December topic?
I can put that I can put it on the agenda for December and try to get some information to the commissioners that would maybe at least give you a little bit of a background on these topics and maybe how many classes we have that are delivered by internet versus classroom for the pre-license and the course for new affiliates, so that you kind of have an idea of what that is.
And I think just because somebody's been teaching a class for many years does not make them a good teacher. I know my daughter had 5 different teachers in 1 week, and she said one of them you could tell was a teacher, and the other 4 had totally lost control of the whole classroom. So when there's 55 people sitting in a room for a class, that's tough on any teacher, and that could happen easily. But I just hate to keep on doing a sweep of if they're approved, they get approved again. And all I know about is what she has told me, so.
Right.
But I think it bears for the Real Estate Commission to not just sign off on all of those things.
Right, I mean, and so I can give you a little background on, like, when the instructors came to pass in 2010, sort of that background, so that'll help start the discussion maybe. And
That'd be good.
So I'll put that on the agenda for December.
Thank you.
So we'll move on to complaints.
Yes, please.
Okay. This should be on your iPads. The total open complaints that we have right now is 290, and we have 20 for which formal charges have been authorized, which means that they've been presented to the commission, a consent order has been sent and not signed, not executed within the time allotted, so that they've been then referred to the litigation department to proceed forward with those. The total number of complaints that we've closed this fiscal year, 7/1 of 2014, to the present time is 110. 68 were closed with no action, and 38 were closed with a consent order, 4 with a letter of warning and instruction. The next page shows the penalty monies collected as of 10/31/2014, and it's broken down by agreed citation, a consent order, and reinstatement fees. And the total amount of money that we collected in October is $48,730. Our total for the year is $190,610. As you can see, the largest amount of penalty money we collect is from the reinstatement fees. And those are fairly substantial, as you can see from this. We don't have the breakdown from last year, so we don't have a comparative number to look at from last year because we didn't break it down by the type of fee that we got. Are there any questions about that? The next page is just another breakdown and actually shows you what's on the disciplinary action report under the consent orders that were paid during the month of October 1 to October 31, 2014. And the next are the pie charts that show, these are, remember that these are the consent orders that have been authorized by the commission. So it doesn't mean that the people have signed these consent orders. This is just based on the legal report and the penalties and the violations that the commission has found based on the presentation by the attorney for probable cause. And right now, since, as I said last month, since it just started July the 1st of 2014, we don't have a lot of movement in the numbers. So far, the thing that has the violation that's most frequently found is 6213-312B14, and that, if you recall, is the portion of the disciplinary statute that allows you to find a violation of, say, 401, like you did this morning, but then bring it in for a penalty through 312. And so that's used, as you saw this morning, fairly frequently. So that's why that has a large, fairly large percentage of the number of violations that have been found. You can see that advertising is 14% and unlicensed activity is 19%. And the second chart really just shows the, and again, this is based just on the consent orders that have been authorized by the commission. So it's not monies that have come into our office, it's just what the commission has authorized. You can see that the largest amount is for unlicensed activity, and this does not include the order that we got the very first part of October for $257,000 because it had not been signed by the judge when I figured all this up. And so, and that would really skew our numbers, I think, considerably. That was the result of a formal hearing.
So just for the audience's benefit, we had a formal hearing where the administrative law judge fined the respondent $257,000.
And that was based on, we had the person had been practicing without a license. They had once been licensed, and then they had been engaging in practice without a license. And we had evidence of a certain number of days that person had been engaged in activities that require a license. So the judge, normally you can give up to $1,000 per day for a violation. And the judge in this instance, because we didn't show a violation prior to the time in question, but we just showed this one portion that was in question in this particular case, the judge penalized the person $500 per day. And I think there were, I want to say 534 days or something. Was that about right? And so they multiplied that, the judge multiplied that by 500 and came up with an amount. And then there were 3 or 4 other violations that the judge found, and it came to, is that right, 257,000? I think that's right. Around that amount. It was a final order because it was a formal hearing heard before an administrative law judge who then issued this opinion and issued the final judgment. So I don't even know the person, we just got it back, so I don't even know if it's been out to the person or not.
So they haven't paid yet?
Oh, no, they haven't paid yet. But I mean, it is an example where where the per day did come into play, and we were able to show that very definite period of time. So but I don't have it in here because it really would skew the monies tremendously. And it was a final order issued by the judge as opposed to a consent order. But just, it is something to keep in mind, I think. Are there any questions about any of that? The next page just shows the property management complaints. The commission asked that those be broken down. And this, again, is just the complaints that are presented to the commission in the legal report from the 1st of July of this year. So the total complaints that presented are 142, and the complaints that involve property management, and that's if it involved property management in any form or fashion, is 18. So that's about 13% of the complaints that have actually been presented this year involved some aspect of property management. And then the last is the disciplinary action report that is online under the Big Commerce and Insurance site, and it just lists the individuals against whom a consent order was issued and who actually have executed the consent order and either completely paid or begun payment pursuant to a payment plan. And if there are no questions about any of those things, the statistics are next. And the statistics, we have a total of 33,969 active licensees, active individual licensees who are brokers, affiliate brokers, or timeshare brokers, which I think is maybe a little different from what your sheet shows, but it is 33,969. That's 91 more than we had last month. Firms, we lost 10 firms this past month. We have 4,090 firms. We have a total licensees of firms and affiliate brokers, and timeshare salespeople of 38,059, which is 81 more than we had last month. We continue to lose retired individuals. And some of that, I think, is we are losing a number of those people with 4-digit licenses, who are the people that have been licensed for a really long time, because we're up to 5 and 6 digits. So it's people who have been licensed for a really, really long time, who may just have been at the point where they would have let their licenses expire anyway. But we do have a fair number of those that we lose every month, it seems like. The next page is the comparative numbers from the last several years, from 2008 forward. You can see that, like in 2008, our active licensees, we had 33,101 compared to the 25,345 that we have as of 10/31 of 14. So we lost 7,756 from 2008 number of licensees. But we have sort of leveled out. We do have 1,300 more licensees this year than we had last year, active licensees. So I think the numbers leveled out to some extent. Ours kind of seems to it doesn't seem to vary a whole lot, the active licensees. I mean, it goes up and then it'll drop slightly, especially during the month, you'll see those variations. But it seems like the worst of the drops are over, at least for the time being. The number, if you go back several pages in the statistics, you'll see the exams that have been taken and the licenses that were issued as of October 31st of 2014. So far this year, there have been 3,214 exams that have been given by PSI to affiliate brokers, timeshare acquisition agents, and brokers, and that's compared to 2,835 last year. So that's a considerable increase over last year of 2013. I'm sorry, those are applications approved, I'm sorry. The exams taken in the next column, we've had 488 exams taken this month, and the total exams this year is 4,658, compared to 3,912 last year. So the exams are up as well as our applications that have been approved during the month since last year. And we still have a number of fingerprints that come in with people with a number of encounters with the law enforcement officials, but I think they're going a little smoother now. Most people are sending in their court dispositions either before or pretty much in conjunction with the arrival of their fingerprints, so that makes the process move a lot faster when we have that information from the applicants already. And so I think that that process has taken almost a year, but I do think it's smoothed out quite a bit, and it's moving a lot faster than it was at the very first when we started fingerprinting. Are there any questions about any of the other statistics? If not, we have the fingerprint facts, and that just is a kind of a picture of the fingerprints and where we stood at the end of the month. The number of applicants that have been fingerprinted thus far is 3,209, and of those, 672 were returned with an indication, and that has remained at pretty much at 21% since it began in January of this year. The number of reports with no indication is 2,704, and the number of reports with no read on prints is 77, and that number stays about the same. And those are people whose prints don't read, and they get to have a second print set taken for free. And then if that's unsuccessful, they'll have them do a paper print that they, actually go physically and have the paper print done. And so among all three of those options, usually one turns out to be successful. So that's not a real problem where people just can't get a read on their fingerprints at all. There are no questions about that. I think that's about everything that was on the.
You got a budget?
Oh, budget, yeah. So I sent the budget to the commissioners early in January, either January or February. Kimberly Whaley, who's been down here before, and Bill Huddleston, who's the new auditor in the administration, will come down and sort of go over the year-end budget. If you recall, they did that this past year, and they'll come down and kind of go over that budget and talk about it and answer any questions that the commission may have about the year-end budget and any questions about the budget in general. But if there are any specific questions about what the commission received, I'll try to answer those. But they will be here in January or February to talk about it.
Any report on the education director position?
No, there's not any report on the education director position. But E&O, I'll tell you a little bit about the E&O. So far, we've had 160 people renew already, so that's a good sign. I've emailed back and forth with Cindy Rice Cindy Rice Grissom, and we're going to work together to try to make sure we reach everybody who doesn't have E&O, and hopefully we don't turn the year with a large number of uninsured people. Our new system won't be up and running by the first of the year, so we would not be able to automatically generate a letter to the people who needed to be suspended. So that makes it even more important that we don't have those large numbers of people who are not insured at the turn of the year. So hopefully we'll be able to do that. Our new auditor, Ahmad, has been working on a list of all the firms with all the affiliated licensees and the principal brokers that we could actually manipulate. Before we had one that you had to paste and copy and you couldn't work with it. So he's finished that, and we're going to use that to send a letter to all the principal brokers reminding them that they are under the rule responsible for making sure that their licensees, affiliated licensees, have E&O, remind them that, it is a supervisory responsibility, and it's considered that under the rule and defined under the rule as that, and that they can be fined up to $1,000 per affiliated licensee. And we're going to send them a list of their affiliated licensees. So hopefully that will encourage the principal brokers to be proactive in making sure that their licensees actually do have it. And a principal broker came in the office yesterday, and I said, don't forget to make sure everybody has E&O. And she said, oh, I've already, that's how we found out this person's license is expired, because we were trying to get E&O for them all. So I'm hoping that that's what, a lot of the principal brokers do, because they don't want that $1,000 per person.
The letters did arrive last week from
The renewal
Rice.
letters from Rice, right. And then she's going to, we're going to work together to try to, they have an email access, and they can't give us their email address, but they can send out, like they did the last time, whatever we asked them to send out under their email. So we'll do that as well. And hopefully, I think did they say like December the 15th, or I think it was early, the 4th. And so hopefully they do have, they have 10 states that renew on 12/31. 2 of the states collect the monies themselves, kind of like what Tennessee used to do. So those aren't really a big concern of theirs. Several of them are, 2 of them are North and South Dakota. They only have like 1,000 licensees. So they're not a real big challenge to get their information processed. Tennessee and Colorado are the 2 biggest challenges to process. And we are the only ones that have a statute that requires suspension if people don't renew in a timely manner and provide proof. So they're really focusing on making sure that ours get processed and get entered into our system in a timely manner, and we, don't face those large numbers of uninsured people that we have in the past.
Well, there's this line that says a principal broker could be fined up to $1,000.
Per affiliated licensee, and if you recall, the rule actually defines, that as a failure to supervise if one does not.
Oh, could it be $100 too? Who makes the decision when it says up to
The
$1,000?
commission can make the decision if they would like to lessen that amount, but it's up to $1,000.
It's not an automatic fine. Is it an automatic fine to the licensee?
It's an automatic fine unless the commission chooses to make it less than that, but the rule says up to $1,000.
We expect a bunch of that in front
You
of us?
might expect some principal brokers, especially those that have, say, 60 licensees that don't get insurance, and they end up with a large bill. They might ask to come before the commission and request that it be lowered.
And the only really true way to know is to have a copy of their E&O in your file on them.
That's right.
That's what I require.
Right, and we have in the past, had, we'd go to the principal broker and say, you've got 5 uninsured licensees, and the broker would say, well, they told me they bought it, or they showed me some receipt, but sometimes, some of those, the checks got returned, or the payment never went through. So the best thing to do is make sure that you do have that true confirmation from Rice that tells you that the person has actually purchased it, or from whomever they choose to purchase it.
And I did mine yesterday, and I got my receipt showing that I had E&O within 5 minutes. So if you can tell them to do it online, it's really quick and easy.
Right, and it is downloaded into our system. Not instantaneously, but it is downloaded into our system, so that if you buy it early enough, you can make sure that it does get there. And if it looks like it's not going to, since it requires proof of insurance, not just that you purchased it, but proof, you could then know that you needed to send in the confirmation like you got, if for whatever reasons it's not getting into our system. Because if, our system, if you have a hyphen in your name in our system, but you don't apply for your E&O with a hyphen, then our system doesn't recognize you. It just doesn't know who you are. So that could keep yours from going through and showing on a download that there's proof of it. If you drop down, you saw there was a drop-down date, and some people dropped down and put 2016 begin. Well, then that's not going to show up as being valid either. So there are things that can happen in the process of actually applying for it that keep us from, it showing up in our system. And Rice tries to go through and capture all those, but then some of them you just don't know, like with the hyphens, or if you've changed your name and didn't tell us and applied for E&O under a different, your maiden name or your not maiden name, however you chose to do it. So those are kind of important things the licensees need to make sure that they do to ensure their E&O goes through in renewals.
Other E&O questions? All right, does that conclude your report, Ms. Maxwell?
It does conclude my report. Next month, as I say, we have several individuals who want to have informal appearances, the number of question 5 people, because we didn't have any come in this month since we weren't sure how long the public hearing would last. So I just, but we do have a number of individuals who do want to come in next month.
Okay, so let me just ask Commission for a second, what you all think about the staff sitting up here instead of down there?
I prefer them being up here.
I do too.
I say whatever they like. It doesn't matter to me. Whatever's most comfortable.
Sitting up here
Yeah,
because on
Keelan
my
said
other
she
commission,
does,
this
yeah.
is where I always sit, so this is a little bit more comfortable for me. I'm flexible.
No, well, I mean, we're good with up here.
Yeah.
Okay, I mean, you're not under some mandate that says you have to sit facing the commission.
I think it's more appropriate, too, for them to face the
Right.
the audience, too, as opposed to having their back to them.
If Keelan's been doing it, then.
So you're okay with moving up here with us now?
Yeah, we were good with it before, but yeah, we're good with it. As I say, Keelan's been doing
Okay, members of the audience, this is an unusual event. We're done, almost. Don't go anywhere. We built in a lot of time today because we had no idea on that rulemaking hearing whether it would take the morning afternoon, and evening, but we're finished in just a few minutes. However, you need to be back here at 9 o'clock promptly tomorrow. We have a formal hearing, so we'll have a judge, court reporter will be back, and you'll get to see the next step in the process of people appealing those consent agreements that we offer to them. All right, I want to ask commissioners if they have any final words before we get out of here. Diane? Austin?
See you tomorrow.
Marcia?
I'm appreciative of our legal counsel today. I know it's a little challenging with all you had to do for today. And then also to congratulate Julie Kropp on the birth of her son, Parker.
Grover?
I'm just glad to be here and see y'all next month.
No, not next, oh, yeah.
Well, thank you, legal staff. I know you had short notice to fill in. Thank you, Kimberly, for a wonderful lunch. You did an awesome job, you and Gil, and we appreciate that. And since we won't be doing comments tomorrow, I'm going to wish everybody a happy Thanksgiving. It's hard to realize it's that time of year again, but commission won't be back until after, so happy Thanksgiving.
Wendell? You ready to go take a nap, or?
Yes, I think I shall take a nap.
I think it's a good idea. Grover, I'm sorry, Gary?
No, I appreciate very much the way you handled everything today, John. Thank you.
Thank you. I'd like to extend that to Eve Maxwell, who was gracious enough to take more than one phone call from me as I tried to figure out exactly how we wanted to put this day together. And ladies, you did a great job as well. Thanks very much. All right, if there's nothing else to be said, we're in recess until 9 o'clock tomorrow morning.
Don't forget to sign out.
Don't forget to sign out.
The year 2014. This is a hearing conducted by the Tennessee Real Estate Commission. Today's commission is chaired by Mr. John Grease and is going to consider the case of Valencia B. Batson, license number 257717, docket number 12.18-127460A. Assistant General Counsel Robin L. Ryan represents the state in this matter. Ms. Valencia Batson, Batson does not appear to be present today, and she's not represented by an attorney today. Let me ask Ms. Ryan, what evidence, if any, does the state have that Ms. Batson was notified of today's hearing?
Thank you, Your Honor. This matter was filed on August 28th and sent both via certified mail and regular mail to Ms. Batson at the address listed with her license, which is 902 Conway Lane, Old Hickory, Tennessee. The certified mail was returned from that address as unclaimed. Our paralegal then researched additional addresses, and certified mail and regular mail was sent to 01204 East Cumberland Avenue, 419 Tampa, Florida, and to 2300 McHugh Road, 306 Houston, Texas. None of the regular mail sent to any of these addresses was returned, but the Florida address was returned unclaimed. But the Texas address was signed for on 10/3 of 2014. I have copies of all of those, and I'd like to submit those as evidence. And then I would like to call Ms. Jenica Smith to testify about further attempts at service on Ms. Batson.
I'll admit those written documents as Collective Exhibit 1. I will distribute the collective exhibit to the board members. There's one copy, and so you just need to hand. That you wanted a witness sworn in so that she can testify about further efforts to reach Ms. Batson?
That's correct, Your Honor.
All right.
I call Jenica Smith.
Ma'am, do you swear or affirm that the testimony you're going to give during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Would you please state your full name for the record?
My name is Jenica Smith.
And your position with the state of Tennessee?
I'm a paralegal for the Legal Division of Regulatory Boards, including the Tennessee Real Estate Commission.
And as a paralegal, were you assisting in the attempts to service a process on this particular respondent, Valencia Batson?
Yes, ma'am.
And what attempts did you make for that service of process, in addition to the original certified mail sent to her address listed with the state?
On September 24th, 2014, I performed a Westlaw Clear search, and the following two addresses appear to be recent current addresses for Ms. Batson. 1204 East Cumberland Avenue, apartment 419, Tampa, Florida 33602. On September 25th, 2014, I mailed the notice of hearing and charges via certified mail, and also via U.S. mail. According to the post office, notice was left for the certified mail letter on September 29th, and it sat unclaimed through October 22nd. I also mailed via certified and U.S. mail 2300 McHugh Road, number 306, Houston, Texas 77056. On September 25th, I mailed it via certified, and it was delivered on October 2nd. We received the domestic return receipt green card on October 16th with a delivery date written as 10/3/2014, and the signature is somewhat illegible.
Did you make any other attempts to contact besides certified or regular mail?
Yes, on September 24th, I called 615-879-2271, which is the phone number that's on file with TREC. I received a voicemail recording that stated I had reached the number and asked the caller to leave a detailed message. Then a voice recording came on in Spanish. We have another paralegal that somewhat speaks Spanish and translated for me.
basically saying something to the effect of, "Nobody is here, thank you for your call," and it hung up, so I could not leave a message.
Excuse me, and that's the number that was listed for Miss Batson with the records of the state of Tennessee?
Yes, 615-879-2271. I also, on September 24, 2014, I called 615-669-7674, which is one of the numbers generated from my Westlaw Clear report, and I received an automated message that asked me to state my name after the tone, and then Google Voice would try to reach Valencia Batson. The phone rang multiple times and went to voicemail, and then it stated that it was the voicemail for Posh Real Estate Group. I left a message stating my name and that I was a paralegal calling with the legal division of the Tennessee Real Estate Commission. I stated that we mailed the notice of hearing and charges to the 902 Conway Lane, Old Hickory, regarding a hearing set before an administrative judge and the commission on November 6, 2014 at 9 a.m. Central. I told her that the certified mail went unclaimed, and I asked her to call me to verify that she received the notice, whether or not she plans to attend, and with or without counsel. And then I asked her to provide a more current address, and then I left my callback number.
Excuse me, did you hear anything back from Miss Batson?
No, ma'am. I also called on September 24th, 615-664-3287, which is one of the phone numbers generated from the Westlaw Clear report, and I reached an automated message recording stating that the phone number was disconnected and no longer in service. And then again on October 30th, 2014, I called the 615-669-7674 number again. That's the one where I was able to leave the voicemail, and I did not get a return call either.
Thank you. Your Honor, I would ask that this court find that there's been proper service or attempts of service on this particular respondent and allow me to go forward on a default judgment.
I find that service has been proper. Members of the commission, you may choose to hold the respondent in default and may choose to proceed in her absence. It's up to the commission members, Mr. Chairman.
Thank you, Judge Williams. Members of the commission, do you have an opinion on this?
I make a motion, we move forward. Second.
All right, I take your motion to mean that you're going to hold the respondent in default and you choose for this hearing to go forward, correct?
Correct.
Commissioner DeCharle makes that motion. It's seconded by Commissioner Franks. Is there discussion on the motion? Hearing none, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed? It passes unanimously, Judge.
All right, then we will proceed in Batson's absence. My name is Madeline Williams, and I've been assigned by the Secretary of State to serve at this hearing as administrative judge. I will make rulings concerning the order of proceedings, the admissibility of evidence, and questions of law under the authority granted me by the Tennessee Administrative Procedures Act, but I will not participate in the findings of fact or the ultimate decision of this board. Those decisions will be made by the commission members. At this time, I would ask that the commission members introduce themselves for the record.
Wendell Alexander.
Diane Hills.
John Grease.
Janet DeChara. Marcia Franks.
Austin McMullen.
Thank you, and there is a quorum of the commission. Members of the commission are reminded that during the time this hearing is being conducted, no discussion of this case should take place between commission members, witnesses, attorneys, or other persons unless all parties are present. The commission sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires all commission discussions and deliberations be in public before all parties. Failure to observe the Sunshine Law may result in the commission's action being reversed or remanded if appealed. Commission members, you should not draw any conclusions until all of the proof has been submitted. Please listen to all of the proof with an open mind. At this time, I would ask the state to distribute the notice of hearing, and I believe the commission members already have the rules and applicable law before them. I would remind members of the commission that the law requires you to disclose on the record any outside knowledge of this case, any communications, written, verbal, or otherwise, from any parties concerning this case. Please look at the notice of hearing to determine whether or not you have a conflict with serving today.
Commissioner wish to disclose a conflict? I hear.
All right, then you all may serve. During the course of this hearing, there will be opportunity for each of you to question each witness that testifies under oath. Please use your questions as opportunities to gain any clarifications of the facts that you feel would assist you in reaching a decision in this matter. However, you must reserve any expression of opinion you may have to that portion of the hearing that's set aside for the Commission's deliberations after all of the proof in this matter has been heard. The pre-hearing technical record in the Valencia B. Batson matter includes the following. August 28, 2014, notice of hearing and charges. October 16, 2014, state's witness and exhibit list. October 20th, 2014, state's motion to have witness testify via telephone. October 30th, 2014, state's amended motion to have witness testify via telephone, 2 copies. October 30th, 2014, opening letter from Judge Williams. October 31st, 2014, state's amended motion to have witness testify via telephone granted by order. Is the state aware of any other documents and pleadings that I have failed to mention?
No, Your Honor.
All right, then that will be the technical record to date. At this time, I'm going to swear in the witnesses, the remainder of witnesses who are going to testify. I'm aware there's one witness who's going to testify by telephone. That witness been reached?
We had contact with him this morning. He is aware and prepared to testify by telephone when I get to that point in the hearing, yes.
Okay, so that one witness will need to be sworn separately.
That's correct.
But the remainder of your witnesses are in the hearing room now, is that
That's correct. There's only one witness in addition to Ms. Smith who's always been sworn, and that would be Ms. Maxwell.
All right, Ms. Maxwell, do you swear or affirm that the testimony you're going to give during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Any preliminary motions or stipulations?
No, Your Honor.
Would you like to make an opening statement?
I would.
If you would, please.
Thank you. This matter today involves sloppy and incomplete accounting at best and failing to account at all at the worst. It also involves a license that has more than one name, and it would appear more than one entity, but only has one license assigned to the name, to the entity. The laws involved are Tennessee Code Annotated 6213-309, which provides that real estate offices must have a license, 6213-312, which provides that failure to account timely for another's money and violation of other rules and laws are reasons for discipline, including revocation, suspension, and civil penalties. In this matter, the respondent, Valencia Batson, is a licensee and a principal broker who managed properties for others using names like Posh Real Estate Group, the licensed business Pure, not licensed, but you will learn that is claimed to be a division, Posh Upscale Real Estate, also not licensed, and PRG, which may be an acronym for Posh Real Estate Group. Through these businesses, you will learn that Ms. Batson managed properties belonging to our witness today, Mr. Dan Orlowski. And you will learn today about 3 properties in particular. You'll learn that these properties were managed by Ms. Batson beginning in 2010 until Mr. Orlowski had to terminate her services in early fall of 2013. And this, you will learn, is due to failure to disperse rents, withholding back rents, and failing to otherwise account for the issue, as Ms. Batson claimed in response that it was she who was still owed monies. You will learn that in total, Mr. Orlansky claims he is owed at least $3,181 after giving credit to the only accounting we have and can give to Ms. Batson. You will learn that nothing she has provided can show the differences and that monies have still not been paid in total that are owed to Mr. Orlowski. You will also learn that although technically she's been served, she's not working to resolve this issue. And you will learn that she started to be in inactive status, but retired her license in fall of this year. When you hear all of the proof, I'm asking that you consider the seriousness of this issue and that you consider revoking her license and charge her with all costs in this matter. Thank you.
Thank you for your opening statement. If you call your first witness, please.
I call Eve Maxwell. Could you please state your full name for the record?
Eve M. Maxwell.
And your position with the state of Tennessee?
I'm the Executive Director of the Tennessee Real Estate Commission.
And as the director, are you familiar with both the license and the complaint files of all licensees?
Yes, I am.
And are you also considered the keeper of the record for license files of licensees for the state of Tennessee?
Yes, I am.
And therefore, are you familiar with the license file and the complaint file of Valencia Batson?
I am familiar with those.
What type of license does she have?
She actually has a retired license at this point. She is a retired real estate broker. Valencia B. Batson holds license number 257717. She got her first license as an affiliate broker on 6/22 of 1995. She became a broker on 9/6 of 2006. And she retired her license and actually renewed it on 9/7 of 2014.
Prior to renewing her license, what status was she in prior retiring?
She was in, she had applied to retire her license in September of, she had applied to retire her license on 3/19 of 2014. At that time, she had completed no continuing education as required by the statute. So she was placed in an inactive status pursuant to the Broker Act. When she completed her education, at the time she renewed on 9/7 of 2014, she then was able to go into a retired status, and that's where she is at this point in time.
And this occurred after these complaints were filed?
That is correct.
What is the company listed as the company she was working with or for?
The name of the company for which she was the principal broker for a period of time and then just was a broker is Posh Real Estate Group, LLC. And they hold license number 260627. She was principal broker of that firm from 8/8 of 2008 until 10/9 of 2013.
And is that company still licensed?
The company's license has expired, and they are currently, the firm is in an expired status. They do have another principal broker, and that person's license is in a problem status because the firm's license expired on 8/7 of 2014.
Have you had any communication from anybody at that firm or the current principal broker concerning the status license of that firm or Ms. Batson?
No, we have not.
What was the reason this complaint was opened?
We received a consumer complaint from Mr. Daniel Orlowski, I believe is I guess that's the way you pronounce it. Mr. Orlowski alleges that Ms. Batson's firm managed 3 properties of his and that monies were owed as a result of that management, that he didn't get the rent monies that were owed, and that there were invoices weren't given to him on a regular basis, and the terms of the management agreement were not adhered to by the licensee.
Did he provide copies of those documents?
He did. He provided copies of the packages that he received from Ms. Batson and the leases that he had that she had entered into with several of the tenants, the most recent leases, and a number of other items that he sent, and then he sent some additional information after Ms. Batson responded to the allegations.
What particular properties were involved in his complaint?
There were 3 properties involved. It was 409A 35th Avenue North in Nashville, 37209. There was a property at 3006 Mossdale Court in Antioch, Tennessee, 37013. And then apparently, at some point, Mr. Orlowski moved out of state and rented his personal residence through Ms. Batson, and that address was 7021 Lexington Point Drive, Nashville, 37221.
In the documents that he provided, what business names were on the documents as providing these services through Ms. Batson?
There were several names that were used in the property management information package, which appears to have been given to Mr. Orlowski early on in the relationship between Ms. Batson and the complainant. The name was P-U-R-E, all in caps, Property Management, and it was from time to time listed as a division of Posh Upscale Real Estate Boutique, LLC. Posh Upscale Real Estate Boutique was the original name of the firm for which Ms. Batson was the principal broker.
Did that firm have a license?
That firm did have a license. When it first opened in 2008, it was called, that was the name that was filed, Posh Upscale Real Estate Boutique. In 2011, the name was changed to Posh Real Estate Group, LLC.
So the original then no longer had a license?
That is correct. It no longer had a license.
But that's the name on some of the documents presented.
That is one of the names. As I say, P-U-R-E, all in caps, Property Management is on some of the leases, and the leases have the variety of the names. It's not just one name, it's several of the names that are on the leases. All were signed by Valencia Batson. A couple of them had PRG, Property Management, on them, and Ms. Batson would list herself as the owner of that. They had, let's see, PRG, Property Management. I think that's, those were the 3 or 4 names that were on the leases and the information.
So we have Posh Real Estate Management, which is the licensee. Is that correct?
It was Posh, we had Posh Upscale Real Estate Boutique, LLC.
Which is not a licensee.
Which is no longer a licensee. Right. And then we had Posh Real Estate Group, LLC, which is the current licensee. Right. And then there was PURE, Property Management, that was never a licensee with Tennessee.
Okay.
And then we had PRG, Property Management, and that's not a licensed firm either. And occasionally it was just PRG Management without any property listed with it. On all of these, Ms. Batson signed as either manager or owner on the leases that were given to TREC.
So there were 4 businesses listed, of which only one has a license. Is that what I'm understanding?
That is correct.
Okay. And on emails from Mr. Batson to Mr. Orlowski, what was the firms or businesses listed from emails to him? Included in the complaint?
A number of emails that he did include. The letters, she refers to Posh Real Estate Group and PRG Property Management.
If you could look at the subsequent information to see if the emails were included in the subsequent information. Let me see if I can. If Your Honor, may I approach?
Yes, yes, you may.
The date?
This was an email from Valencia Posh Real Estate Group, and she has managing broker owner Posh Real Estate Group, LLC, on that particular email.
What was the date on that email?
April the 10th, 2013.
Date and the name of the group on it?
This is an email sent from Valencia Batson, January the 4th, 2013, to the complainant, and it's listed as PRG Property Management in this particular email.
So in the emails as well as in the document itself?
She does, that is correct. The leases, each of the leases actually refers to the name in two or at least two different ways.
What is the law concerning business licenses for real estate?
A firm that's a person who's engaged in activities that are defined in 6213-102, 4A and B has to have a real estate license in order to engage in the activities that are defined in that portion of the Broker Act. In order to have an active real estate license, you have to be affiliated with a licensed firm. And every licensed firm, as set forth in 6213-309, has to have a principal broker and a fixed location and adequate facilities for licensees that conform with the zoning laws and the ordinance.
As well as a license?
As well as a license, correct.
So each of these businesses that she refers to would have had to have a separate license?
That's correct. 6213-309A1A says each office shall have a real estate firm license, a principal broker, and a fixed location with adequate facilities for affiliated licensees located to conform with zoning laws and ordinances. And then Rule 1260-2-.03 again says each real estate license firm shall display the firm's place of business a sign which contains the name of the firm as registered with the commission, being the Tennessee Real Estate Commission, and it shall comply with the zoning ordinances. And then there's several other provisions in 6213-309 that require, if there's a branch office, each branch office has to have its own principal broker and own firm license.
Now, you said earlier that she's no longer listed as the principal broker, is that correct?
That is correct.
But there is someone still active in this business listed as a principal broker?
That is correct. The current principal broker is Dominique Deshawn Batson, and that individual holds a broker's license, and it's number 319325.
Thank you. Now, going back to the complaint itself and the documents provided, and his own personal accounting, does Mr. Orlasky say what is owed to him on the property at 7021 Lexington Point Drive in Nashville?
He says that the 7021 Lexington Point Drive, he's owed a total of $2,815.
And what did he said is owed to him about 409A 35th Street?
On 409A 35th Avenue North in Nashville, the complainant says that he is owed $688.
And what about the property at 3006 Mossdale Court?
3006 Mossdale Court, Antioch, Tennessee. The complainant alleges that he is owed $3,924 for a grand total owed of $7,427.
And with his complaint, he included documents that support the lease agreements, et cetera, that he had with this particular respondent?
Yes, he did, and he also included the PURE Property Management Group. It's a management agreement. It's actually just sets forth what each party must do. It doesn't appear to be signed by either party, at least the copy that is in our file does not, but it's called the Property Management Information Packet, and on the front of it, it says PURE Property Management, a division of Posh Upscale Real Estate Boutique, LLC, and it lists the address, and it goes through a number of things that the PURE Property Management team will do for the individual owner of the property.
Your Honor, I would like at this time to have that complaint filed as my next exhibit and pass out copies to the commission for their review. Thank you.
Copies of the complaint are admitted as Exhibit Number 2, and it may be published to the commission members.
Ms. Maxwell, did Ms. Batson file a response to this complaint?
She did file a response to the complaint.
And what did she say in response to the various firms and names?
She basically said that the names were acronyms for her firm's, the original name being Posh Upscale Real Estate Boutique, and she said that that was the first name that she had, and then that PURE, Property Management, a division of Posh Upscale Real Estate Boutique, stood for Posh Upscale Real Estate, and PRG Management, she says, is an acronym when the name changed to Posh Real Estate Group, LLC. PRG was the acronym for Posh Real Estate Group.
Did she address why she didn't bother to get licenses or change the license or name or anything with the state concerning all these particular, quote, divisions?
She did not really speak directly to that issue.
What did she say about the money that Mr. Orlowski said was owed to him?
She went through a series of mainly written documents that she said that she showed that she didn't owe him any money because, in fact, that she had a 10% premium that would have been added to repairs that had been made, and that he, in fact, owed her money at this point. And even though a number of the repairs had taken place at the beginning of their relationship was in 2010, I believe, was the beginning of their relationship. And she said that so he owed her money and that she had conducted a number of repairs throughout the time that she had managed these houses and that that money had been spent on repairs. She did give a handful of invoices, but the invoices did not total nearly the amount of money that were spent on repairs.
And were any of those any of those invoices provided recent, or were they all old? In other words, were any of them for the year 2013 or later in 2012, or all prior to that? Or there dates on all the invoices as well?
Here's one, 8/31/13, and you can't tell what it's for. There's no date on this one. The date's cut off on one of them. There's not a date on another one. So there are not dates on there are only like a handful of them, and there are not dates on the bulk of them.
And did she provide any documentation concerning the 10% she said was due to her?
That was
not been paid?
Not an assigned agreement. As I mentioned earlier, there was a PURE, property management sort of informational packet, and in that particular packet, which doesn't contain signatures of either party, it did list that they take a 10% premium on repairs that were done and that they supposedly oversaw.
Did she provide any documents or accounting that only one rental payment was due on the Mossdale property, which is what she claimed?
Her accounting is rather difficult to follow, so you can't really tie in the dollars in and the dollars out in the invoices that are submitted with the documentation.
Did she provide any additional information to help resolve this issue?
She really did not. She provided the leases as the complainant had done. They are the same leases which she provided, and that's the largest part of her response. She provided the tax returns that she would have given the complainant as the manager of the property. So she sent copies of those, and they really didn't offer much information. And then she has a summary of how those tax figures were arrived, and it shows repair numbers that are not supported by invoices that are included in her response. And then she just has copies of what looks like probably their property management program that prints out and shows the net income, the money in and the money out, but you can't really follow the information that she gave.
At this time, Your Honor, I would like to have her response as the next exhibit and have them passed to the commission as well.
The response is entered as Exhibit Number 3, and it may be published to the commission members.
Did Mr. Orlowski then do a follow-up after receiving the response from Ms. Batson?
He did, indeed, he filed a response to her response, and he filed that on 1/6 of, he wrote it on 1/6 of 2014. We actually received it on 1/14 of 2014. And he noted on that there was an updated amount that was owed, that he had received some additional money on October the 18th of 2013 from Ms. Batson, and so that the current amount that was still outstanding was $5,483. And then he responded to Ms. Batson's statement, particularly the one that she said that he now owed her money for the 10% premium that she would have added for repairs that had been done. And he, said that many of those had happened over 3 years ago, and again, that the invoices didn't tie in, the very few invoices that she had sent did not tie back into the bank statements, nor could they be traced back to the property. And then he noted that his tax returns were then incorrect. If what she was alleging was correct, then the tax returns that she submitted to him were incorrect for him to submit with his own taxes.
Did you provide any other documents or anything with that response, or just that's the gist of the response?
When he responded to the response, he did not include any additional documents. He just went through an explanation of what she had said in response to that.
So, given what she provided, he attempted then to do an accounting as well, additionally? Yeah.
What he did, it appears,
Yeah.
is that he took his original information and then took her responses and tried to match those two together and respond to the main differences and then bring up the tax return information.
Your Honor, I would like please to have this response to the response as the next exhibit and have them pass to the commission.
Response is entered at this time as Exhibit Number 4, and it may be published to the commission.
Ms. Maxwell, what law governs how a licensee is to handle the monies owed or owned by another that is a client?
6213-312B5 specifically says, the commission may, upon its own motion, shall upon the verified complaint, the writing of a person setting forth the cause of action in this section, ascertain the facts and warranted, hold a hearing for reprimand or for the supervision or revocation of a license. The commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of failing within a reasonable time to account for or to remit any monies coming into the licensee's possession which belongs to others.
So Ms. Batson has a responsibility then as a licensee to do proper accountings for monies, whether it's through a sale or for a rental agreement?
That is correct. She, as the principal broker, is responsible for the escrow monies or any monies that belong to a third party that come into her possession.
Now, this complaint was filed in 2013, is that correct?
That is correct.
And as far as you know, since the filing of the complaint, have the issues of the difference in accountings ever been addressed by Ms. Batson?
Not to my knowledge.
So it's been at least a year then since, or close to a year, at least since the complaint is filed, where there has no been an absolute accounting for the differences?
That is correct according to our records.
Okay. I have nothing further for this particular witness.
Members of the commission, this is your opportunity to ask questions of the witness.
Commissioner McMullen.
Thank you, Mr. Chairman. Just want to clarify, if I could, and make sure I understand what's going on here with respect to the names. There was a firm that was called Posh Upscale Real Estate Boutique LLC that was licensed. And in 2011, the name was changed to Posh Real Estate Group LLC.
That is correct. When the license was first issued, it was Posh Upscale Real Estate Boutique, and that was on 8/8 of 2008. And they changed their firm name. Ms. Batson changed the firm name, and it, as of 4/28/2011, was changed to Posh Real Estate Group LLC.
And so, is it a violation to use these other names that she used, whether they're acronyms or something different, whenever she is with a firm that was licensed, but she used these other names as well?
Yes, you can
Is
only
that
be
a vi- is
you
that
can
a
only be
violation of
affiliated
309?
with one firm at a time.
Okay.
6213-309 says E, 6213-309E3 says, "No more than one license shall be issued to any broker or affiliate broker to be in effect at one time." That provision, that section also states that each branch office or every office shall have a principal broker and a firm license, so that she couldn't operate but for one firm, and those other firms would have to have had separate principal brokers and be licensed and operating as a licensed real estate firm in order to engage in activities that are defined in the Broker Act under 6213-1024A and B.
Okay, thank you.
Ms. Franks?
Ms. Maxwell, have there been any other complaints filed, or has there been any actions against Ms. Batson?
No, there have not, to my knowledge.
Other questions? Can I follow up on Commissioner McMullen's question as far as dates go? So I think you testified that Posh Upscale Real Estate Boutique was licensed 8/8/2008.
That's correct.
Can you tell me when Posh Real Estate Group LLC was licensed?
That name changed, so they have the same license. Each
Okay.
has the same license number, which is 260627. So it was a name change
Okay.
that was from Posh Upscale Real Estate Boutique LLC. And then on 4/28/2011, the name was changed to Posh Real Estate Group LLC.
And Ms. Maxwell, in Ms. Batson's answer to the complaint, she herself has written here the different names, the PURE, the PRG. I think it's on like the third or fourth page of the complaint response. So, I mean, she acknowledges she's using all these names because she sent this to the Real Estate Commission.
That is correct. This was her response to us. And those names are included in the leases that both she included and the complaint included. They're spread throughout the leases.
Other questions? I think that's it, Judge.
I just want to be clear, Ms. Maxwell. The name Posh was used in, I think, in October of 2013 in a termination letter or termination service that Ms. Batson provided in the complaint. He has a copy of it with the complaint.
Where she wrote him on October, I believe, the 15th of 2013.
That's correct.
And she terminated her services after he had terminated her services previously.
And what's the name on that document? On the top of the page.
To find the document first.
May I approach
Yes, you may approach.
At the top, it says Posh Real Estate Group, termination of services.
And the date on that?
And the date on this is,
It's in the body of the letter.
Oh, that's right, terminated October 15th, 2013.
And could you turn the next page?
This is the portion of the bottom of this page says, "Thank you in advance for your cooperation in this matter," and it's typed in, not signed, but typed in where it would be a signature, PRG Property Management.
So at least in 2013, subsequent to 2011, when the name was something else, she's still using the other name.
Correct, and they're in the leases, which go from 13 to 14 as well.
Thank you. I have nothing further for this witness.
Additional questions from the commission members?
I have a question. I know that there was she was sent mail to Texas. Did she have a company in Texas? I know she can't.
I didn't look at that information.
Your Honor, that would call for a redirect or a question for.
That would be a question for another witness.
That's fine.
I can tell you that her address with us is Conway Drive in Nashville. Her address registered with the commission is that address.
Okay.
So, may I, Your Honor, so I'm still confused, Ms. Maxwell. The letter that Ms. Ryan just asked you to find the date in was a termination letter from Ms. Batson to the complainant.
That is correct.
And which company's name did she use in that letter?
She used Posh Real Estate Group, and then she also, where the signature, as it were, would have been, is typed in PRG.
Okay, then what confuses me, is in the complainant's affidavit. He says, and he's at least has stated in here, that he found that Posh Real Estate Group LLC was dissolved through the Secretary of State through 10/17/2013. So can you confirm that if even Posh Real Estate Group was actively licensed at that point, or is that a separate issue?
Well, I actually have the information from the Secretary of State's office, and it shows that there was an administrative dissolution. There have been several, but if you start at the most recent, there was an administrative dissolution revocation on 8/9/2014. There was a notice of a termination on 6/3/2014. The firm was reinstated as active with the Secretary of State on 10/17/2013. And then it had been it had been dissolved once before in 2012 and several other times since.
So that's my question. So if they were reinstated on October 17th, 2013, then on October 15th, 2013, they were not considered an entity by the Secretary of State, I guess, but from a Real Estate Commission's point of view, was Posh Real Estate Group LLC active at that point?
It was an active firm at that point. It had a valid license with the Tennessee Real Estate Commission, and it had a principal broker as well at that time. The Secretary of State's, they have they were, as I say, it was dissolved administratively in place. It was placed inactive, and it was changed at the Secretary of State from active to inactive, and then was dissolved administratively. That information affects us initially, but in an ongoing manner, we are not advised of these, changes that might take place because of a failure, say, to file your annual report on behalf of an LLC or a corporation.
Does that dissolution, does that automatically or technically do away with an active real estate license?
No, it does not.
Okay, thank you. Honor, at some point when you think appropriate, we'd like to take a break up here for a few minutes.
If the court, please, I would just like to have Ms. Smith answer the one question and then.
Perfect. Thank you, Judge. Thank you.
I'd like to recall Ms. Smith to address Ms. Frank's question.
All right.
Ms. Smith, you're still under oath.
Yes.
So, in your research in attempting to get service, did you also attempt to call the state of Texas and their real estate division to see if there were any licenses applied for or any active businesses with Ms. Batson in Texas?
Yes, ma'am. Once we received confirmation of service in Texas, I called, I first looked up the licensees on the Texas Real Estate Commission website on October 16, 2014, and it did not appear that Ms. Batson was licensed with the Texas Real Estate Commission. So then I called the Texas Real Estate Commission to inquire whether she had even applied for licensure, and the lady I spoke with stated that there had been no record of Valencia Batson.
Thank you.
Thank you.
I have nothing further, Your Honor. And the next witness I would call will be Daniel Orlowski, but we will have to, that would be a good time, that's correct.
How long a break, Mr. Chairman?
How much time do you need, Ms. Ryan?
We need about 5 minutes.
We need about 5 minutes. Thank you.
Right, sure, thanks. We're back in session from recess at this time. Mr. Orlowski, I'd like to swear you in. If you'd please raise your right hand after me and be prepared to respond to one question. Do you swear or affirm that the testimony you're going to give during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right,
Thank you. Mr. Orlowski, this is Robin Ryan. I'm the attorney that is litigating this matter and will be asking you the questions this morning. Would you please state your full name for the record?
Daniel Michael Orlowski.
And your address, Mr. Orlowski?
215 Manor Road, Southbury, Connecticut, 06488.
I assume that because you're in Connecticut, it would have been a long distance to come here to Tennessee this morning.
Yes, ma'am, it would.
Okay. How do you know Miss Batson?
She was my real estate agent and property manager.
When did you first hire her?
It was April 2010.
And for what properties did you hire her?
My first property I purchased was on 35th Avenue North, and then a few months later I purchased a property on Mossdale Drive, and then eventually when I moved to Connecticut, my primary residence became another rental property which she oversaw.
And what property address was that?
7021 Lexington Point Drive.
So after you're purchasing these properties, are you then saying that she managed them as rental properties for you?
The first two, as soon as I purchased them, she immediately began managing them as rental properties. Lexington Point was my primary residence. She was my real estate agent for purchasing it. However, I lived there for approximately a year before moving to Connecticut, and then it became a rental property.
Thank you. Is she still your manager?
No, she is not.
Do you have a current property manager?
I do.
And who is that manager?
It is Jim Hodge with Apex Ventures, Inc.
Why did you cease doing business with Miss Batson?
Well, many reasons. But basically, as the final few months of our relationship, a bunch of my properties were behind on rent, and it was becoming more and more clear that this wasn't just the tenants weren't paying her. So ultimately, the straw that broke the camel's back Actually, I had a tenant move out of my Lexington Point property, and that tenant, none of the tenants had my numbers at this point. However, this tenant did some sort of online search to get my parents' number. She found my parents' home number somehow. Called my parents and was complaining about Valencia. I thought we resolved that situation. That was just a quick situation where she had moved out and she needed her security deposit back. And ultimately, what happened was a whole month went by and she had not received her security deposit check. So I ended up sending her a security deposit check. I guess Valencia did actually have one in the mail, but it didn't get to her by the end of the 30 days. And apparently Valencia was being unresponsive with her. And that was kind of the straw that broke the camel's back. But at the end of the day, I was more concerned with the fact that pretty much every single property I had was behind on rent.
So when did you send her or attempt to terminate your relationship with her? When did you fire her?
I 9/2/2013, I sent her an email basically telling her that I wanted to terminate my business relationship with her effective immediately.
And after your termination, did you then look at what was owed you on various properties?
I did.
What is owed you?
Oh, go ahead.
Okay, well, I was going to start with the Lexington Point. What do you believe, or your record shows, owed to you on your property at Lexington Point?
One second. So, what was owed to me when we terminated our relationship on Lexington Point was $2,815.
And is that for rent not paid?
That is for rent not paid, but it's a little bit more complicated than that.
Okay.
If I may explain, basically when I first signed up with Valencia in her property management agreement, I needed to keep a portion of money set aside for repairs. So the way we set that up was out of the rent every month, she would take, between $15 and $100 out of that rent to set aside in what I believed was a separate account. I'm not sure if it actually was, but what I believe was a separate account to cover repairs on the property. So, she called them throughout our relationship. She called those accounts many things. She called them escrow accounts. She called them trust. And what else did she call them? She called them one other thing. But basically, they were just repair accounts. And I actually got a balance from her, several, 2 weeks before I let her go. I got a balance. I had her send me a record of the balances of these accounts. After I terminated the relationship with her, these accounts, I don't know what happened to them. But I was using her when determining this. Unfortunately, I never had access to these accounts. These accounts were not in my name. But these were rents collected that were not for her. They were for me. She just held on to them for repairs on the property.
Is that the reason she says?
This money was supposed to be returned to me.
Is that the reason she says that you owe her money on this property?
That is the reason that she is using. She's saying that a portion of her repair commissions from when I first bought the properties was not paid out.
Did she provide you documentation showing all repairs that were made on this property in Lexington Point?
No, she did not.
Okay. Did she ever provide an ultimate accounting so you could look at what she claimed were the problems and what you claim were the problems? Did she ever clear that up with you on Lexington?
No, she did not.
Well, thank you. Let's look at the 409A 35th Street. What do you state is still owed to you on this property?
This one, my balance is $688, and if I may just kind of hold you for a second there. These balances were the balances I sent at the time I filed the complaint at Tennessee Real Estate Commission. I did receive $1,944. However, I'm not sure which property those $1,944 came from.
And when did you receive that check, the 1944?
I received that check on October 18th.
Of this year?
No, 2013.
Thank you.
October 18th, 2013. I did receive 1944. But these were the balances. These are the balances of the individual properties. I don't know where that 1944 got allocated from.
Okay.
Whether it was for Mossdale or Lexington or 35th.
Now, on 35th, you said that the rents owed you were $688. What was her response concerning what monies that she said was owed to her on this property?
What was her response?
Yeah, what did she say she was owed from you on this property?
Did she give an amount?
Well, or let me back that up. How did she respond, or what did she say about the $688, if anything, that you say is owed to her? Owed to you, sorry.
She said that the repairs of the properties when initially purchased, she didn't take her 10% commission for repairs when the property was initially purchased and rehabbed. And she also mentions advertising fees of $200.
Did she provide any documentation to support those claims?
No.
Did she ever provide an ultimate accounting so you could look at the differences and come to a reconciliation based on what you said you were owed and what she said was owed?
No.
Let's look at 3006 Mossdale Court. What is owed to you on this property?
$39.24 is what was owed to me.
No, Mossdale, I'm sorry, Mossdale Court, is that $39.24?
$39.24 prior to receiving the 1944. Once again, I don't know how that 1944 was allocated between
Okay.
the three properties.
I'm sorry, say that amount again, I'm sorry, how much?
$3,924.
Thank you. And was that for rents not paid to you?
That was for rents not paid to me and the repair accounts.
Did she ever offer an explanation on this property about why she felt she was owed money on it?
She believed that there was commissions not paid on repairs as well as advertising charges.
Did she provide documentation to support that there was money owed or any repairs done?
No, she did not.
Did she ever give a final accounting on this property so you could reconcile the differences between what she said was owed and what you said was owed?
No, she did not.
Now, after you terminated her services, were the escrow deposits paid to her turned over to your new management company?
No, they were not.
So, since October 2013, when she sent you that one check, has she paid any money owed to you?
No, that is all.
And did your new management company also attempt to contact her and try to resolve these issues?
My new management company attempted to contact her. I don't believe it was to resolve these issues. My new management company contacted her to get keys to the property, to get leases, and things like that. But they did not really stick their head in this. In this.
Okay. And so as of today, and this is in November 2014, the monies from these properties as of termination in September of 2013 are still not accounted for and they're still owed to you?
That is correct, yes.
I have nothing further for this witness, Your Honor.
Members of the commission, this is your opportunity to ask questions of Mr. Orlowski.
Members of the Commission. Mr. Orlowski, this is John Grease. I have two quick questions for you. Were each of did each of those three properties have security deposits that belong to tenants?
They did, yes.
And do you know how much those three security deposits total?
Security deposits. You're gonna have to give me a second here. On Lexington Point, the security deposit was $12.50. On the security deposit was $400 on 409 35th Avenue North. And the security deposit was $500 on 3006 Mossdale Court. And Mossdale Court and 35th Avenue North still have the same tenant.
I'm sorry, would you make that statement once more?
35th Avenue North and Mossdale Court still have the same tenant. Actually, since I own the property, they have the original tenant in there.
What, the Lexington Point Drive, you said that there was a security deposit of $1,250. Was that turned over to the tenant when they vacated?
That was ultimately, yes, that was turned over to the tenant when they vacated, and then there was a brand new tenant in there, but unfortunately, I don't think I have the lease for that. Right before she left.
Oh, it's possible there's a current tenant at 7021 Lexington Point that has a security deposit with the respondent.
Oh, no, the security deposits were turned over.
That's so your Apex Ventures Inc. has all the security deposits for each of the three properties?
Yes.
All right.
Security deposits were turned over, that is correct.
Okay, I'm sorry, I was confused about that. My last question has to do with the check that you received October 18th for $1,944. Do you recall what company that check was written on?
I believe it came from real estate group. I could probably pull it up. Hold on one second. It might take me a minute to pull this up. I don't know if you want to come back to this question.
That's my final question, so I'm happy to wait.
Okay.
Mr. Orlowski, as I look through the paperwork, on 10/19, I see that First Tennessee Bank issued a cashier's check to you, and the remitter was Posh Real Estate. So I think I've answered my own question. I'm sorry.
You found it? Okay.
I'm sorry I
I'm
put you
sorry.
through the effort to
I'm
look.
sorry, I got a stack of papers here a mile high.
I know you do. I apologize for that. Thank you, sir. Thank you, Judge.
All right, thank you.
Questions of the witness?
I have one question. This is Marcia Franks, Commissioner. Mr. Orlowski, do you have a written agreement as to what was going to be furnished to you by this company?
Can you rephrase the question? I'm unclear what you're asking.
Do you have a property management agreement with Ms. Batson that you signed that states what monies, you mentioned ad fees and repair fees would come out of your monies. Do you have a signed agreement with her to that effect?
Yes, ma'am. It was included in the packet I initially sent. I do not have the original signed copy, if that's what you're asking.
Okay, but you did sign it.
Yes, ma'am.
And what did it say about ad fees? Do you recall?
I believe it was $200 for renting out ad fees, but if you hold on one second, I got it right in front of me here. Just says one-time setup for clients. I don't know if it specifies a number. Oh, here we go. Lease renewal fee, prepaid advertising, $200.
And is that per property or per month, or what were the terms of that?
There may be other fee numbers. It does not say. It does not specify how they will be levied. My understanding of it was they were per every time your unit turned over and you had to get a new renter in there, it would be one $200 fee.
Okay, thank you.
Understanding of it.
This is Janet DeChara. In Ms. Baston's report, she states that she sent you a monthly report on the rents. Did you ever receive those?
I, in 3 years of doing business with her, maybe received one or two that I can recall. And what actually happened with that was she converted. She never really sent me anything directly. She did convert. She tried to include it in her thing. She did convert to an online system, and unfortunately, I can't recall exactly when. I'm gonna guesstimate it was probably about a year before our relationship ended. So I went to an online system, and I remember trying to get set up on it, and I had all these problems. And she kept telling me she was having problems with the system. So ultimately, I never did the online system she had. I didn't have a login. I didn't have a password to it. You know, I had it to, and it just wasn't working. Uploading. And I was having trouble getting on, stuff like that. So, and that was the last I ever heard of this online system. Other than that, my statements were unfortunately an Excel spreadsheet that I kept and what was received in my bank accounts.
Okay, thank you.
I think that's.
Any redirect, Ms. Ryan?
I don't think so, thank you.
All right.
Thank you, Mr. Orlowski. We're going to hang up the phone in the system at this point.
All right, thank you.
Thank you.
I would have any additional witnesses?
I do. I'd like to recall Jenica Smith. Ms. Smith, you stated earlier you're a paralegal, is that correct?
Yes, ma'am.
You're not an accountant.
That's correct.
Okay. But did you or have you attempted to try to look at the documents provided by both parties to reconcile the differences?
Yes, I did my best to record them on an Excel spreadsheet.
And based on the documents provided to you by Ms. Batson and the documents provided to you by Mr. Orlowski, what did you conclude concerning various amounts owed on the various properties?
I did two separate spreadsheets, one for what Mr. Orlowski claimed was owed to him, and one compiling the information that Ms. Batson sent. I was able to understand Mr. Orlowski's accounting and deduct from the lease agreements the property management fees and things, and I came up with the amount that he explained to you. On the information given to me, or given to the legal division from Ms. Batson, I could not add up what she was stating was due to him or owed to her from the complaint with the documents that she attached.
Did you spend a substantial amount of time on this?
I spent a couple of days on it.
And even after a couple of days and giving her a benefit of the doubt, you still couldn't reconcile what she provided?
No, I couldn't quite understand. She had, Mr. Orlowski mentioned the online system, and you can see in your packet that there are income and expense reports. I believe those are screenshots from the online system, but they're rather confusing. I couldn't tell what was deducted and why. And then she submitted, as you can see in your packets, different invoices for repairs and the tax documents, but just none of them equal. There was one Excel spreadsheet that I was able to use and go off of that she provided to Mr. Orlowski a couple of weeks before their termination. That was kind of the basis of what I started my spreadsheet on. That and the lease agreements made the most sense with computing what was collected and what was owed.
Could you find anything to support her allegations that she was actually owed money from Mr. Orlowski in
Well, the property management agreement, the ones that we have, she submitted one and so did he. They're not executed, but they do state the advertising fee and the deductions. But it's hard to tell if it. She didn't submit an accounting, so I don't know if she took it out initially in 2010. We only have the lease agreements for the current tenant, so I don't. No, there was no accounting of if she took it out when the leases commenced. There was no actual accounting of like the money that was deposited into her bank statements or into her bank accounts, her trust or whatever account. And then there weren't very many checks showing that she had paid him.
So at the conclusion, did you find, though, information to support his claims that he was still owed certain amounts on each of these properties?
It appears so. If we don't deduct the 10% commissions that she claims were owed in 2010 that she never took as of 2013, then it appears that what he's saying he is owed is correct.
Thank you. I have nothing further for this witness.
Ms. Smith, just one quick question. Was that, when you heard the testimony this morning, that he'd received a check for $1,944? Was that new information to you?
No, that's included in the additional information that he submitted. It's the smaller packet that you received, dated January 15th, 2014. He didn't give a copy of the check, but as you saw, she had responded. It appears that she submitted a check to him after she received the complaint and as she was compiling a response. And so she included that as the last check in her response, and that was something that I had noticed, and then as I was compiling the accounting, he submitted and told us that she had paid that.
So, did you include that in the spreadsheets that you worked on?
Yes,
And so-
yeah.
And your sense is he's owed approximately how much based on your spreadsheet?
$5,483.
Ms. Smith, we've got quite a lot of documents here, and I haven't quite waded through all of them, but to your recollection, did you see any receipts from Ms. Baston showing repairs or what kind of repairs were done, or what I'm seeing is just says repairs.
Yeah, there were some invoices and like property condition reports. There's like a handwritten one. It's cut off though, so it's hard. There's a couple of job invoices in there. One of them's for the 35th Avenue North, 425 repair and replace tile and bathroom floor upstairs. $40 for the Antioch 37013. I might have an easier way of doing this because I did record that on the spreadsheet that I created. There were a couple, long story short.
But not enough to justify. I saw on one accounting, she was saying one of the properties had like over $13,000 in repairs.
It didn't appear to be that extensive. I did note on a couple of those screenshots she gave that she was withholding some of the rent money to go into a separate repair account. And the spreadsheet that she provided him, and I'm not sure I can find it off the top, but it did kind of have an outstanding balance of what was in that account. And again, I can't recall if that was in addition to the security deposits. Toward the end of the new matter transmittal, his initial complaint, there's that Excel spreadsheet. When he requested a total of what was in those accounts, the repair accounts. But no, I couldn't relate what she was saying with how many repairs were made to the property based on the few invoices she provided.
Thank you.
Other questions? All right, Your Honor, I think we're good.
Witnesses?
No, Your Honor, that concludes the state's proof.
All right, would you like?
I would. All licensees are required to be honest and straightforward, and a part of that requires them to make timely accountings for monies that are in their possession that belong to others. From the testimony today and from extensive attempts by even our department, the information provided by this respondent does not account for the money owed on properties of Mr. Orlowski. She does not provide documentations to support her claims. She actually didn't bother to further support anything, and she has not paid what is owed to Mr. Orlowski according to not just his accounting, but for what we can ascertain from the information sent to us. While we don't require licensees to be accountants, we do require them to be honest and straightforward and to make in a timely account. These monies were owed to him at the end and termination of the contracts in, at the latest, October of 2013. It is now November of 2014, and accounting has still not been made in its entirety that can timely address the issues and monies owed. And as far as we can tell from everything provided, Mr. Orlowski is still owed in excess of $5,000 for the properties that he owned and entrusted to Ms. Batson. Additionally, Ms. Batson had a firm name that she established when she got started and changed that name, but apparently still did business under various names, not just the new name, but including the former name, including some acronyms, and called them divisions of the licensed property, licensed organization. The law provides that each division or each separate entity of a division requires its own license. She was acting as principal brokers for at least 3 other firms at the same time. Even though they were all in the same particular office, they were listed as 3 separate groups and acknowledged, apparently even by her, as 3 separate groups. This is the kind of deceptive and misleading practices that are very dangerous to the public at large, as you can see as the result of what happened to Mr. Orlowski. He entrusted properties to her, believed that she was taking care of them and doing timely accountings, and yet when he asked for those, she could not provide answers to the questions about why these monies are still owed to him. And all she provided was information stating that somehow monies are owed to her for something she didn't do in 2010, but provide no documents to support that. This is exactly the kind of licensee we don't want to be a licensee. And when I finish today, I'm asking you to consider these facts very carefully and ask that you revoke her license and ask that you please charge her with the cost of this hearing today. Thank you.
Those findings for the commission members?
I do.
All right, you may distribute those at this time.
I think that'd be appropriate. Thank you.
Commission has now heard the proof in the case of Valencia B. Batson, license number 257717. In the Batson matter, the state is seeking that the respondent be disciplined for allegedly violating the Tennessee Real Estate Broker License Act of 1973, found at Tennessee Code Annotated 62-13-101, particularly Section 62-13-312B5, concerning failure to account for or remit monies belonging to others. Section 6213-312B14, concerning violating any provisions of the chapter or rules, and Section 6213-309, regarding each office having a real estate license, a principal broker, and a fixed location with adequate facilities for affiliated licensee. A 56-1-308 permits the Commission to assess civil penalties for violation of statutes, rules, or orders. TCA 56-1-311 and Rule 780-5-11-.01 assess respondent the actual and reasonable cost of investigating and prosecuting this matter. As sole and exclusive finder of facts in this matter, you must conduct open deliberations and make findings of fact and reach conclusions of law based on the facts found, determine the penalty, if any, that is appropriate, and determine policy reasons for your decision. You must make findings of fact based solely upon the evidence presented before you in this hearing. Evidence includes the testimony of witnesses as well as any exhibits introduced. The notice of hearing filed by the state is not evidence but may be used as a guide to assist you in making your findings, but it's the sole responsibility of the Commission to make its own findings of fact. The attorney has argued her respective theory of this matter. The statements of counsel are not evidence, but are merely arguments to persuade you to see the evidence in the light most favorable to their particular position. Give such arguments whatever, if any, consideration you feel is appropriate. In making your findings, the Commission must determine the credibility and weight to be given to the evidence presented by each witness. If there's conflict in the testimony between witnesses, it's the responsibility of the Commission to reconcile those conflicts if possible. But if it is impossible, the Commission must make the determination as to which witness to give the greatest. Reaching this determination, the Commission should bear in mind the following. The law presumes that all witnesses who are sworn to the oath testify to the truth. It's the obligation of the finder of fact to attempt to reconcile any discrepancies in the testimony between witnesses, but if this is impossible, then it's necessary for the triers of fact to determine which witness speaks the truth and which witness has stated a falsehood despite his or her oath. In determining which witness is believable, the Commission members, as fact finders, have wide discretion. However, the Commission members should consider, in determining the truth, the witness's interest, if any, in the outcome of the matter, their good intentions, their seeming honesty, their respective opportunities for personal knowledge of the facts about which they are testifying, as well as their conduct and demeanor on the witness stand. Before the Commission should consider any possible disciplinary action, the Commission must first determine whether the state, the petitioner in the Batson matter, has met its burden of proving the charges that it has brought by a preponderance of the evidence. If the Commission finds it helpful, it may weigh the evidence mentally on the scales of justice. If the scales tip in favor of the state, the Commission must find for the state. If the scales tip in favor of the respondent, the Commission must find for the respondent. If the scales are evenly balanced, the Commission should bear in mind that the state has the burden of proving the charges. The respondent does not have the burden of proving that she or he is innocent. If, after a full and impartial review of the evidence presented to you, the commission feels that the state of Tennessee has carried its burden of proof by a preponderance of the evidence, the commission must then, based on its findings of fact, determine whether the conduct of the respondent is such that she is guilty of either one, none, or all of the charges. If the commission finds the respondent guilty of a charge or charges, then the commission may take appropriate disciplinary action. If, after a full and impartial review of the evidence presented to you, the commission may find, for example, that respondent has not violated the real regulations, the commission could find that the respondent has violated the Real Estate Brokers Act and that discipline of the license is warranted. Another example, respondent has violated the Real Estate Brokers Act, that discipline of the license is warranted and that civil penalties may be imposed. Further, that respondent should pay the cost of the proceeding in addition. In assessing the alleged violations and appropriate penalties, if applicable, the commission may consider any evidence that the parties have introduced, including but not limited to whether the conduct was or is of a continuing nature versus a one-time occurrence, whether the amount imposed will be a substantial economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation and the risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, and the overall interest of the public. Additionally, the commission may also consider what it has done in previous similar matters for comparison purposes. I mention these examples of possible discipline for illustration only and not in any effort to sway the commission in its determination. Chairperson Grease, please proceed with the deliberative process, establishing findings of fact, conclusions of law, and policy reasons for your action.
Thank you, Your Honor. Commissioner McMullen.
Mr. Chairman, thank you. I would like to make a motion that we adopt the following finding of fact. 1, the respondent was, at all times pertinent hereto, licensed with the Tennessee Real Estate Commission, having been issued license number 257717.
Second.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara to approve that finding of fact. Discussion. All in favor say aye. Aye. Those opposed, no. That motion passes unanimously.
Mr. Chairman, I make a motion that we adopt the following proposed finding of fact. Number 2, the respondent was, at all times relevant herein, the principal broker of Posh Real Estate Group, LLC, a licensed real estate firm.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara to adopt that finding of fact. Discussion. Let's vote. All in favor say aye. Aye. Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 3, this matter is before the commission based on a complaint filed by Daniel Orlowski. Mr. Orlowski is a property owner and respondent managed complainant's 3 properties, parenthesis, open quote, the subject properties, close quote, close parenthesis, located at 409A 35th Avenue North, Nashville, Tennessee, 3006 Mossdale Court, Antioch, Tennessee, and 7021 Lexington Point Drive, Nashville, Tennessee, from 2010 until September 2013.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara to accept this finding of fact. Discussion. Let's vote. All in favor say aye. Aye. Those opposed, no. That finding of fact is included.
Mr. Chairman, I move that we adopt the following finding of fact. 4, Mr. Orlowski stated that respondent did not disperse rents from the subject properties and as of January 2014 was withholding back rents. After the termination of property management services, respondent withheld escrow repair funds for the subject properties.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara to accept that particular finding of fact. Is there a discussion? All in favor of the motion, say aye. Aye. Those opposed, no. That finding of fact is included.
Mr. Chairman, I move that we adopt the following finding of fact. 5, pursuant to the Excel spreadsheet provided by respondent to Mr. Orlowski via electronic mail on August 20th, 2013, the escrow repair balances through July 2013 were as follows: $1,729 for the property located at 3006 Mossdale Court, $510 for the property located at 409A 35th Avenue North, and $1,700 for the property located at 7021 Lexington Point Drive.
Second.
You've heard the motion made by Commissioner McMullen, seconded by Commissioner Nachara. Any discussion? Let's vote. Those in favor vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 6, between the time of the Excel spreadsheet accounting of the escrow repair balances provided by respondent and termination of property management services, Mr. Orlowski stated that 2 additional rent escrow deposits in the amount of $100 each were made to each of the properties located at 409A 35th Avenue North and 3006 Mossdale Court.
Second.
All right, the motion's in front of the commission. Discussion. The motion made by Commissioner McMullen, seconded by Commissioner Nachara. Let's vote. Those in favor of the motion say aye. Aye. Those opposed, no. That motion passes.
Mr. Chairman, I move that we adopt the following finding of fact. 7, in additional information submitted by Mr. Orlowski, he acknowledged that a check with a notation by respondent that the check represented the final escrow payment for the property located at 3006 Mossdale Court was sent to him by respondent after the initial complaint was filed with the commission.
Second.
You've heard the motion offered by Commissioner McMullen, seconded by Commissioner Nachara. Discussion. All in favor of the motion say aye.
Aye.
Those opposed, no. That motion passes.
Mr. Chairman, I move that we adopt the following finding of fact. 8, respondent has collected the following rent payments and has not dispersed the rents to Mr. Orlowski for the following properties. A, for the Lexington Point Drive property, 1 month's rent payment less respondent's commission and a test deposit amount. And B, for the Mossdale Court property, 3 months' rent payments less respondent's commission, lawn care, and test deposit amounts.
Second.
You've heard the motion and second offered by Commissioner McMullen and Commissioner Nachara. Discussion on the motion. Let's vote. Those in favor say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 9, in a response to the complaint, respondent stated that rents have been dispersed for the subject properties and that the different amounts and outstanding balances were reflective of outstanding balances determined to be owed to respondent's firm.
Second.
You've heard the motion offered by Commissioner McMullen, seconded by Commissioner Nachara. Discussion. All in favor of that motion, please vote aye.
Aye.
Those opposed, no. Motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 10, with regard to the alleged escrow repair funds owed, respondent states that there were multiple occurrences where the escrow repair balance for 409A 35th Avenue North was depleted, and funds were drawn from another property to cover expenses. To support this statement, respondent attached Excel spreadsheets displaying escrow repair balances for December 2010, September 2011, November 2011, and May 2011. But respondent did not account for or provide documents to demonstrate what occurred with regard to the escrow repair balances indicated in the Excel spreadsheet provided by respondent to Mr. Orlowski in August 2013.
Second.
Motion made by Commissioner McMullen, seconded by Commissioner Nachara to accept this finding of fact. Is there discussion? All in favor of the motion, vote aye. Aye. Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 11, respondent states that after termination of services in October 2013, it was discovered that the 10% premium charged on all repairs had not been collected from Mr. Orlowski, and the $200 prepaid advertising expense had gone uncollected as well, and therefore there was an overall balance owed to respondent's firm from Mr. Orlowski.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara to accept this particular finding of fact. Is there discussion? All in favor of the motion, vote aye. Aye. Those opposed, no. Motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 12, documentation provided by respondent does not provide a clear accounting of the money paid to respondent and for what it is owed, nor does the documentation adequately demonstrate that the money which respondent claims is owed for repair premiums and advertising was not already paid.
Second.
You've heard the motion offered by Commissioner McMullen, seconded by Commissioner DeChara. Discussion? All in favor of the motion, vote aye. Aye. Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 13, respondent was associated with multiple businesses, including, but not limited to, Posh Real Estate Group, LLC, PURE Property Management, and PRG Property Management.
Second.
We have a motion offered by Commissioner McMullen, seconded by Commissioner DeChara. Is there discussion?
I have a question. Were there not four?
Yeah, that's my point too. Would you like to speak to that?
I was thinking that there were four companies, not just those three.
There was a company called Posh Upscale Real Estate Boutique, LLC,
Right.
that Commissioner McMullen, you may want to include in that motion.
Tell you what, why don't I withdraw that motion and make a new one?
Okay. Is that all right with you, Commissioner
It
Chara?
is.
Okay.
Mr. Chairman, I move that we adopt the following finding of fact. 13, respondent was associated with multiple businesses, including but not limited to Posh Real Estate Group, LLC, PURE Property Management, PRG Property Management, Posh Upscale Real Estate Boutique, LLC.
Second.
You've heard the motion.
Hang on.
Okay.
I thought I had one more. And PRG Management.
Second.
Okay, the motion includes now 5 different entities.
I'm thinking the PRG property and PR property management and PRG management, are they not one and the same?
Find both names used in different places.
Okay.
All right, the motion includes 5 entities. It's been properly seconded by Commissioner DeChara. Is there discussion on the motion? Further discussion? All right, let's vote. If you're in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 14, among the documentation provided was a property management information package from PURE Property Management, tax summary reports from PURE Property Management, monthly owner statements from PURE Property Management, residential lease agreements with mold/mildew addendums from PRG Property Management, a property management information package from PRG Property Management, and a tenant packet from PRG Property Management.
Second.
Motion offered by Commissioner McMullen and seconded by Commissioner DeChara is in front of the commission. Is there discussion? If not, let's vote. Those in favor say aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 15, respondent states that PURE Property Management and PRG Property Management were divisions of Posh Real Estate Group, LLC. However, neither PURE Property Management nor PRG Property Management are licensed, nor have they ever been licensed by the Tennessee Real Estate Commission as real estate firms.
Second.
Motion offered by Commissioner McMullen, seconded by Commissioner DeChara, is in front of commission. Is there discussion on the motion? All right, let's vote. Those in favor say aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 16, respondent signed a residential lease agreement on behalf of PRG Property Management for the lease of 7021 Lexington Point, Nashville, Tennessee.
Second.
Motion by Commissioner McMullen was seconded by Commissioner DeChara, is in front of the commission. Is there discussion on the motion? All in favor of the motion, then please vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 17, respondent signed a residential lease agreement on behalf of PRG Property Management for the lease of 409A 35th Avenue North, Nashville, Tennessee.
Second.
The motion made by Commissioner McMullen, seconded by Commissioner DeChara, is in front of commission. Is there discussion? Hearing none, let's vote. All in favor say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 18, respondent signed a mold/mildew addendum on behalf of PRG Property Management as lessor of 409A 35th Avenue North, Nashville, Tennessee.
Second.
Okay, the motion made by Commissioner McMullen, seconded by Commissioner DeChara, is in front of commission. Is there discussion? Mr. McMullen, may I ask, would you restate that finding of fact?
Sure. Respondent signed a mold/mildew addendum on behalf of PRG Property Management as lessor of 409A 35th Avenue North, Nashville, Tennessee.
Further questions or discussion? Let's vote. All in favor of the motion say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 19, respondent signed a residential lease agreement on behalf of PRG Property Management for the lease of 3006 Mossdale Court, Antioch, Tennessee.
Second.
Motion made by Commissioner McMullen, seconded by Commissioner DeChara. You've heard the motion. Is there discussion on the motion? All in favor of that motion, vote aye. Aye. Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following finding of fact. 20, respondent signed a mold/mildew addendum on behalf of PRG Property Management as lessor of 3006 Mossdale Court, Antioch, Tennessee.
Second.
Motion is made by Commissioner McMullen, seconded by Commissioner DeChara. Commission has heard the motion. Is there discussion on it? Let's vote. All in favor say aye. Aye. Those opposed, no. That motion passes unanimously. Are there other findings of fact from any member of the commission? All right, as I understand it, Your Honor, our next charge is proposed conclusions of law. All right. Mr. McMullen, can you help us with that?
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code annotated Section 62-13-312B5 states in relevant part, the Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee, in performing or attempting to perform any of the acts mentioned herein, is found guilty of failing within a reasonable time to account for or to remit any monies coming into the licensee's possession that belong to others.
Second.
Okay, Okay, we have a motion by Commissioner McMullen, seconded by Commissioner DeChara, speaking to a particular conclusion of law. Is there discussion on the motion? All right, all in favor say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Respondents' acts and conduct as described in the above findings of fact constitute a violation of Tennessee Code Annotated Section 62-13-312B5.
That's the one we just did.
Right. We just, the first motion set out what the statute says, and this one would find that what the respondent did was a violation of that
Okay.
statute.
All right. Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara. You've heard the conclusion of law that Mr. McMullen is trying to get into the record. Is there discussion on that? Let's vote. All in favor say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. The respondent's acts and conduct as described in the above findings of fact constitute grounds for disciplinary action and civil penalties and the assessment of investigatory and hearing costs pursuant to Tennessee Code Annotated Section 56-1-311 and Tennessee Comprehensive Rules and Regulations, Section 0780-5-11-.01.
Second.
Are you certain on that comprehensive?
Maybe it's compendium, I don't know. Comprehensive, there you go.
You are certain on it, thank you.
I wasn't certain, but I may have been correct.
All right, you have a motion properly made by Commissioner McMullen, seconded by Commissioner DeChara. Is there discussion on the motion? All right, let's vote. Those in favor say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code Annotated, Section 62-13-312B14 provides in relevant part, the Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by a false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of violating any provision of this chapter, any rule duly promulgated and adopted under this chapter, or the terms of any lawful order entered by the Commission.
Second.
Motion properly made by Commissioner McMullen, seconded by Commissioner DeChara, is in front of the commission. Is there discussion? Let's vote. Those in favor of the motion say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code Annotated 62-13-309D1 states, if the applicant for a broker's license maintains more than one place of business within the state, the applicant shall apply for an additional firm license for each such branch office.
Second.
Motion is made by Commissioner McMullen, seconded by Commissioner DeChara. Is there discussion on the motion? All in favor of the motion say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code Annotated 62-13-309E states that no more than one license shall be issued to any broker or affiliate broker to be in effect at any one time.
Second.
All right, the motion made by Commissioner McMullen, seconded by Commissioner DeChara is in front of the commissioners. Discussion on that motion. All those in favor of the motion say aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code Annotated 62-13-309A1A states, each office shall have a real estate firm license, a principal broker, and a fixed location with adequate facilities for affiliated licensees located to conform with zoning laws and ordinances.
Second.
You've heard the motion offered by Commissioner McMullen, seconded by Commissioner DeChara. Is there discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code Annotated Section 62-13-102 4A states that broker means any person who for a fee, commission, finder's fee, or any other valuable consideration, or with the intent or expectation of receiving the same from another, solicits, negotiates, or attempts to solicit or negotiate the listing, sale, purchase, exchange, lease, or option to buy, sell, rent, or exchange for any real estate or of the improvements thereon, or any timeshare interval as defined in the Tennessee Timeshare Act, compiled in Title 66, Chapter 32, Part 1, collects rents or attempts to collect rents, auctions or offers to auction, or who advertises or holds out as engaged in any of the foregoing.
Second.
All right, the motion is in front of the commission. It's made by Commissioner McMullen, seconded by Commissioner DeChara. Is there discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code Annotated Section 62-13-102-13 states that person means and includes individuals, corporations, partnerships, or associations, foreign and domestic.
Second.
Motion made by Commissioner McMullen, seconded by Commissioner DeChara, is in front of the commission. Is there discussion? Hearing none, let's vote. Those in favor say aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code Annotated Section 62-13-103A states that any person who directly or indirectly for another, with the intention or upon the promise of receiving any valuable consideration, offers or attempts or agrees to perform or performs any single act identified in Section 62-13-102, whether as a part of a transaction or as an entire transaction, is deemed a broker, affiliate broker, or timeshare salesperson within the meaning of this chapter.
Second.
You've heard the motion offered by Commissioner McMullen, seconded by Commissioner DeChara. Discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code Annotated Section 62-13-103B states that the commission of a single such act by a person required to be licensed under this chapter and not so licensed constitutes a violation thereof.
Second.
Motion made by Commissioner McMullen, seconded by Commissioner DeChara. It's up for your consideration. Is there discussion? All in favor of the motion, vote aye. Those opposed, no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Respondents' acts and conduct, as outlined in the findings of fact above, constitute a violation of Tennessee Code Annotated Section 62-13-312B14 and Tennessee Code Annotated Section 62-13-309.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara. Is there discussion on the motion? Sure, take your time. All right, let's vote. Do you have any comments or questions, Mr. Franks?
No.
Okay. If you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously.
Mr. Chairman, I move that we adopt the following conclusion of law. Respondent's acts and conduct as described in the above findings of fact constitute grounds for disciplinary action and civil penalties, the assessment of investigatory and hearing costs pursuant to Tennessee Code Annotated Section 56-1-311 and Tennessee Comprehensive Rules and Regulations Section 0780-5-11-.01.
Second.
You've heard the motion offered by Commissioner McMullen, seconded by Commissioner DeChara. Any discussion on the motion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, do you want to do the actual disciplinary phase as part of the conclusions of law, or is that a separate?
Let's make it separate.
Okay.
Is that appropriate, Your Honor, to determine the
It's
penalty?
done both ways.
Oh, have
Either
you?
way would be fine.
Okay, you're kind of driving right now, so it's,
I don't have any other conclusions of law that I
right.
would suggest then.
so at this time, let's see if we can determine the appropriate penalty.
Mr. Chairman, I move that, based on the findings of fact and conclusions of law that have been adopted, that the commission revoke the license for the respondent and impose on the respondent the investigatory and hearing costs.
Is there a second to that
Second.
motion? Okay, the motion in front of commission is, as I understand it, to revoke the respondent's license and charge that respondent with all costs associated with this hearing. Is there discussion on the motion? All right, hearing none, I sense we're ready to vote. If you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. All right, Mr. McMullen, I'm going to see if you want to help us one more time and give us a policy reason for that decision.
Sure, I'll give it a shot. I move that we adopt the following policy justification for our action. The failure to account for and remit funds held by a licensee that belong to others is a serious offense that implicates the very reasons that citizens employ licensees, a belief that the licensee will be trustworthy and exercise reasonable care and diligence. This licensee's failure to comply with this most basic of requirements justifies revocation of the licensee's license and imposition of costs in order to protect the citizens of the state of Tennessee. This failure alone would be enough to justify revoking the license. But here we have the additional fact that we have a firm that is not licensed by the state that is acting in a way that would require a license. The statutory structure that we have here is intended to protect the citizens of the state of Tennessee. And when a firm is not licensed but should be, the citizens are not being protected. And so this further justifies the revocation of the licensee's license, although the failure with respect to Section 6213-312B5 in itself would have been sufficient to justify the revocation.
Second.
Okay, you've heard a potential policy statement to justify the action of this commission. Is there discussion on Mr. McMullen's motion and Mr. Chara's second? All right, I hear none. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Your Honor, I think I'll turn it back over to you if we've completed our charge.
Yes.
Thank
You
you.
have completed your charge, and this hearing is concluded. Thank you.
Thank you, Your Honor. Let's see, this is a portion of the November session of the Tennessee Real Estate Commission. Is there other business to come before the Tennessee Real Estate Commission? I sense that the people in the back of the room are about as ready to get out of here as we are. This meeting is closed and done. Thank you for attending. Make sure you sign out.
As I got out of